again, on behalf of the House Study Committee for Bioprivacy, I'm the chairman of the committee, Representative Ed Setzler from North Cobb County. I want to thank all of you for being here today. I apologize for our late start. We have a committee member who's not going to be here today, who was kind of touch and go with a medical condition with his mom, his elderly mom, and Representative Calvin Hill won't make it, so we were trying to accommodate his needs. That being said, I'd like to go around and have everyone in the room introduce themselves. My goal is to address the issues we have before us today adequately, but not exhaustingly. If we can finish early, we will. If we can't, we won't. But I think there's a lot on the table today, issue-wise, that's of interest to the committee that I want to make sure we address adequately so that the state can have addressed them and looked at them adequately moving forward with some policy concerns. That being said, again, for everybody's interest, the Biological Privacy Study Committee was initiated last session with House Resolution 1558, which in essence was created to look at the issue of indelible biological information. That's information about each of us, from fingerprints to photographs to DNA to a whole number of ways that biological information can be captured and maintained. And to look at a number of contexts in which it's maintained and made available to make policy decisions or to consider policy decisions to ensure that the values of the people of Georgia are reflected in Georgia law. You look at biological information and you consider what are the uses of it, from law enforcement context to identification purposes to medical information to tracking and ID verification. There's a number of technologies available that can use it and use it in a very profound and useful way. We want to make sure that the uses that are important for us and appropriate for us as a community to use are made available to us and are able to be expanded upon, but that the uses that might be inappropriate in terms of striking an unhealthy balance between individual rights versus the rights of the state or the rights of private institutions, that a balance be struck to make sure that we're staying where the folks of Georgia would want us to be as a state. So that's really the inspiration of the study committee and why we're here. And to that point, I'd like to introduce Representative Sharon Cooper, Cobb County. She's a member of the committee. Representative Barry Loudermilk, Representative Tyrone Brooks, myself, and again, absent today is Representative Calvin Hill. To that, I'd like to go around the room briefly and have everyone stand up and introduce themselves so we know who's in the room. As we move forward today, it's going to be a fairly informal setting, much more of a subcommittee kind of feel. We'll have speakers up. They'll have an allotted amount of time to talk and present. But if there are questions from the committee, I'd like to be able to stop folks as we go. And if there are answers from the audience that can shed light on the issue, I'd like to be able to recognize folks to do that. So don't be bashful about raising your hand. If a question comes up that you think you can entertain and speak to in an important way, be sure to raise your hand so we can do that. That being said, I'd like to start with Jennifer and go around the room and have introductions.
Schmidt, I'm with UCD and Government Affairs Department.
I'm Tish Bell, I'm just a concerned citizen. I'm Sue Ellen Wilder, volunteer lobbyist and newsletter reporter, which I'm very interested in this. Thank you.
I'm Pete Donaldson on behalf of the Georgia Criminal Defense Lawyers Association.
I'm Misty Haskins, partners with Mr. Lawson.
I'm Kim Kimbrough, Assistant General Counsel for the Association of County Commissioners.
Wilkie, Chief of Police for the City of Ackworth and representative of the Georgia Police Chiefs Association.
Bob Keller, I'm the Executive Counsel for the Prosecuting Attorneys Council.
I'm Ann Thompson, I'm a legal attorney for Prosecuting Attorneys Council.
John Banky with Georgia Bureau of Investigation.
I'm Dan Kirk, the Director of Crime Lab at GBI.
Ted Staples, GBI Crime Lab, DNA Unit.
I'm Maggie Garrett, I'm with the ACLU of Georgia. Amy Maxwell, Georgia Innocence Project.
Sandra Michaels, lobbyist for GACDL.
Rick Russell, from the Legislative Counsel's Office.
Appreciate you guys being here very much. Again, I want to make sure we use our time wisely today. We are going to be working through lunch. Gactel has graciously provided us lunch today. I think we've got plenty of lunches for all the folks here. So if you plan on staying through, there should be enough to feed all the mouths we've got. So again, we'd like to push through, and we'll take periodic breaks as necessary. But to that point, I want to walk us through briefly the agenda before we get started. Again, Jennifer, have you made these available to all the folks?
Actually,
Okay, got a couple extra versions here. Okay. We've got an agenda for today's meeting, and we have a draft agenda for the September 27th meeting. We're going to have two testimony-driven meetings of the study committee. Today is the first. Our first meeting was just an organizational meeting. Today is the first real meeting where we're taking testimony and having discussion. Today's focus is on biological information in law enforcement contexts. On September 27th, we'll have our second meeting, which is really looking at the other contexts, from insurance to medical practice to personal identification, business use, research and development, and so forth. So the agendas for today and the draft agenda for next meeting are provided to you. That being said, are there any questions before we get started from anyone in the committee or anyone in the audience about how we'll be moving forward today? Hearing none, I'd like to recognize, on behalf of the Georgia Prosecuting Attorneys Council, we've got Bob Keller today. Bob, are you going to be making the presentation?
Yes.
Okay. Bob, if you could, please.
I will ask Ann if she would just come up and tell us if there's anything. Ladies and gentlemen, I want to thank you on behalf of the Prosecuting Attorneys Council of Georgia, which represents the district attorneys and solicitors of the state, for the privilege of being here. One thing you understand and learn quickly as you get older is that you rely on young minds and young talent to do some of the real work when it comes to researching things. And I want to commend Ann for some of the work that she did in getting us prepared, or attempting to get us prepared to make this presentation and everything, and I thank you for it. I'll be very candid with the study committee. When we got the notice or the invitation to speak, I hadn't thought much about the subject of this. I had not given it much thought. It's something that was just not on my radar screen, and so obviously trying to be prepared, I learned a little bit more about why the study committee was formed, and I would just want to go ahead and tell you how much I appreciate what you're attempting to do. This is a huge issue, and I hate to act ignorant about it, but I realize with some of the things that are happening on the national level, with the talk of national ID cards, with the talk about how to combat terrorism and what the government should or should not do, that this is an issue that is going to affect all of us. And it's always refreshing to know that Georgia is not going to sit by and take a back seat, but that Georgia, through a study committee like this and through our legislature, will do what is necessary, not only to protect society, but to protect individual rights. And so when we start talking about this situation and we start looking at the concerns, I want to emphasize that the Prosecuting Attorneys Council, or the prosecution community, is very aware of the necessity for balance. This is not a situation where we want to be part of a big brother. We're going to look after you, and we're going to invade you under the guise of protecting. If we protect society to the detriment of individuals, then we have not done what we need to do. And so you are not going to hear from prosecutors that we are going to be opposed to legislation that strikes that balance. Now, the dilemma, and I've been doing this so long, that the first thing that you do when you have a study committee, you want to know what they're going to do. First thing you want to know is, all right, what you planning? Let me look at your proposed legislation, and then I'll give you I'll give you an opinion as to what is our position on this. Well, obviously, that's what the study committee is designed to do. What do we need to do? What are you looking at? Are there gaps in the current law? Futuristically, where are we going with the technology and the advances that we've got in the gathering of information? And then based on that, then of course that's when the legislation comes. So in an attempt to basically talk in terms of a prosecution position, it's a little difficult to articulate with specificity exactly how we feel about certain things, but I'll attempt to just sort of go through some of the things that we've got. When you talk about the concept of ID cards with biometric identifiers on it, that certainly creates some fear when we're talking about stuff like that, because it basically means, and I'll steal a phrase from Pete, who is going to speak a little bit later, when he said he can see you getting stopped, and the next thing the police officer says is, give me your information, give me your papers, and the next thing you know, he reads off a little card and it says everything about me. You know, that weight that hadn't been right in 15 years, the height that, you know, used to be right 15 years ago, but now has, you know, decreased a couple of inches with time, and then who knows what else. And that, yes, indeed, I have. We know all about you, and so. But if you look at how Georgia is moving in this area, Georgia's moving away from this. Up until 2005, we had the fingerprint on driver's license, and this legislature decided that we would not do that. Yes, I know exactly how that came about. But my point is, so you know, in Georgia right now, Georgia's reaction to that through its legislative has been to back away from that. So we do not have the ID identifier situation that we've got in Georgia. Now, the biggest thing that we've got are the biometric database that we've got in Georgia, and I'm not going to talk about this in a lot of detail, because after speaking with the GBI, they are better equipped to address that. But it's our DNA database, and that's what we've got. And for those of you that recall, we had a situation now that the legislature through statute has, we require convicted felons who are incarcerated to give up a DNA sample. So if you're going into the Georgia prison system, you are going to give a DNA sample. The constitutionality of this has been ruled on. It was ruled on in 1997, and it basically said that the Court of Appeals of Georgia upheld the constitutionality of the statute, saying that this was a situation that did there were no constitutional violations when you're dealing with this. And we're talking about a convicted person. We have another interesting. Yeah, yes, sir.
Just a question about the database you were talking about with the convicted person. Is that felons and for misdemeanors?
No, just felons.
Just for felons.
Just felons.
Okay.
And just felons, Representative, that are incarcerated.
Okay.
So in other words, if I, for instance, get, and this is a good point, and this is getting to, and this is a policy issue that this committee will have to address, and that is, and I'll get into it just a little bit longer. Do we need to expand that, and where do you, and if you expand it, how far do you go? But right now,
so I'm sorry, just to clarify. So currently, if you're convicted of a felony and incarcerated, DNA is taken, but if you're convicted and some other diversion happens short of incarceration, they don't collect.
That's correct.
Okay.
That's correct. Now, and they are, and I'm just going to sort of move through this, there are protections that are set up in the statute about the accessibility of this database, who can get it, who can't get it, how it's protected, and it is pretty well protected in that sense. We have another database or another gathering of information, and this is as a result of some things that occurred, and it really grew out of, and I don't know whether Amy is going to testify or not, but if Amy Maxwell, who is I know here with the Georgia Innocence Project, came out of some of the cases that involved people who were subsequently found innocent after incarceration. And I happen to have one in my circuit in 1983. We convicted Calvin Johnson of a rape. And it was a horrific crime, and it involved the use of a similar transaction. It involved the use of, to the extent that you can call it, eyewitness identification. There was some identification. Unfortunately, this is not a situation of eyeball to eyeball facial identification, because the perpetrator of this crime did not show his face, and so the victim could only talk in terms of appearance, voice, and other things of that nature. There was a conviction and a life sentence, and there was no DNA. This was back when there was no DNA, and so this was just a crime. I mean, it was just a situation where you had 12 members of a jury, and they found guilt beyond a reasonable doubt, and then you had a sentence. The entire time, Calvin Johnson's maintained his innocence, and this is not out of the ordinary. A lot of times defendants maintain their innocence even after conviction, and rightly so. However, in 1992, there was an interesting situation that occurred in Clayton County, and that was a judge had retired. A new judge was coming in, and a court reporter was no longer going to be the court reporter. And this was the court reporter that had handled this case. And back in those days, court reporters maintained evidence of cases. And so I sent some investigators up to the court reporter's office to see if there was any evidence that we needed to keep. And in a waste can were some evidence from the Calvin Johnson case. And they called down and said, "Hey, Bob, you want us to keep this?" Now, I would love to tell you that I had a crystal ball. I would love to tell you that there was a logical basis of keeping it. I'd love to tell you there was a legal basis of keeping it. There was none. We will not get into a religious discussion, but I happen to believe in miracles, and if you do also, this is a miracle. And there was this is 1992. This is 9 years after the conviction, and for whatever reason, I told them, "Sure, bring it up to our evidence." The rest is history. 5 years later, we got a call from the Innocence Project that wanted to know, do we have the DNA? Yes, we do. I mean, we've got samples. Well, could you consent to a DNA test? Yes, we did. The DNA proved it was not Calvin Johnson. The charges were dismissed. He was released. He, along with some other excellent advocates, formed the Georgia Innocence Project. Amy is the chairman of that, and then we worked with legislation that talks about the preservation of possible DNA evidence when there is not a perpetrator. There is a horrific crime. The police officers go to the crime scene, and under the Georgia statute now, they're required to gather evidence that would be potentially produce DNA that would lead to an identification of a perpetrator if there was ever a perpetrator caught. And I won't go into what the statute says you keep, but if there's a way to test it, then there is a retention situation. Now, from a privacy standpoint, and from a situation of an invasion of the, and when you look at a balancing here, we've got a society protection issue versus have we violated anyone's rights? Well, we don't know who this person is. We don't know if this person will ever be identified. So in that situation, you look at our database or this collectible evidence that could initially produce something, and you see that is something where the protection of society outweighs any type of invasion, because no one's been invaded. This is evidence that's left at a crime scene. This is not anything that was required of someone to produce, on their own thing. So that is another database that we have that or potentially that we've got. We've got the fingerprint situation about when you can fingerprint, when you can't fingerprint. The GBI is going to address that and everything. If you move down, the line, so to speak, you can look at other things that could potentially be invasive, and we talk about video surveillance. You've got statute protections now about video cameras in private areas where there's an expectation of privacy. That's prohibited. Cameras in public areas where there is no expectation of privacy gets into a an area about how can there be public backlash, and depending on where those cameras are, there could be, and then that's a balancing of a government right, like your tickets are, the camera as you go through the intersection versus the camera that is in front of the ATM window that you got. Yes.
Could you speak to that for me? The expectation of privacy, where you draw the line, and what kinds of areas can surveillance go on? Just general surveillance without a warrant, but just general looking, and how that can be used, and what's admissible, what's not admissible. Things.
Well, gosh, dog, and I will call on my colleagues that are back there to correct me if I am wrong on this. But let's talk about a bathroom, for instance. I mean, you can't. If I go into a stall, I have an expectation of privacy, and so I don't expect to see a camera in there, monitoring, my every move. You've got an expectation of privacy in a phone booth as it becomes to an eavesdropping situation. However, if I go to a public place, then there is not an expectation of privacy because I am out in the open. If it can be viewed by other people, it could be captured on camera. And so if I take any attempt, and I don't mean an attempt to hide in a public place, but if there is anything that is restricting access in where my location, for instance, like the bathroom, like the phone booth, that is away from public view, then you get into the situation about how can you get into that? Can there be a camera there, or can there not? And then you've got the interest of the public. We had a situation that we just heard about that occurred. A new restaurant opened, and the new restaurant wanted to know what the waitresses thought about the ownership. So they put a hidden microphone at a waitress station to capture the conversation of the waitresses, and they were monitoring what the waitresses were saying about the cooks and what the waitresses were saying about the owners and everything like that. That is a definite no-no. There was no way that there was not an expectation of privacy. If we were having this conversation, if Representative Cooper and I were having this conversation outside the public and everything, but we were standing at a place, that there was a hidden mic. So that would be an example where you would not have that. The different cameras with the law enforcement, with the speeding and everything, where you run that, you have what I always like to call is the rolling stop, and that is there's no reason to stop completely, especially at night when you can see both things coming. Well, the camera captures me, and I did not make a complete stop. Is that evasion of my privacy? Well, I'm out in the open. I'm clearly in the public eye, and so that has not been something that has been, I don't like it. I don't like Big Brother looking at me and taking my picture when I'm violating the law. How dare they do that? But, here again, I was right out there, in the public view.
I have a question that was dealing with being out in public, but being in your automobile. Has the courts or anyone looked at, are you expected to have an expectation of privacy while you're actually enclosed in your automobile, even though your automobile might be out in public?
Well, here again now, there is an expectation of privacy as to what the law enforcement officer can do as it relates to your automobile. In other words, a law enforcement officer just stops me, and a law enforcement officer says, Mr. Keller, you were speeding. let me give you your driver's license. Well, the expectation of privacy to my automobile is, unless there is some type of probable cause, law enforcement can't invade my vehicle. So that's, if you want to put it in a privacy situation, you should have an expectation of privacy unless there is something that comes to law enforcement's attention. You can have plain view. He looks in there, and for anyone to see who is in his position, there is, drugs, which then puts it in a different issue. But there is let me put it this way, there's more of a constitutional protection against an unauthorized search without probable cause, which would, I think, you could equate into an expectation of privacy.
I'm sorry.
Go ahead.
But when we're talking about photo enforcement of traffic violations, we're not really talking about the expectation of privacy that would exist within the vehicle, because you're watching the movement of the vehicle itself, which is readily observable, not as opposed to looking at something that's being done inside the vehicle.
Okay, and that answered the question I was going to ask, is dealing with well, let's go beyond the traffic cameras, because I know in Georgia, I believe that it's that we have that in code that the camera can't take a picture of the occupant, that it's just taking a picture of the vehicle license plate or its position in the intersection. But what about other surveillance cameras? Has that ever been addressed? Is there an expectation of privacy in your vehicle from other type of surveillance, or do the cameras are just looking at your vehicle?
I'm trying to think if we have cameras that would even do that. The only cameras that I can think about would be ATM cameras that would capture a location, and by virtue of that location, if your vehicle came within that location, it would then could conceivably capture something there. But that's the only thing I can't think of. I can't think of a thing where a camera would be doing anything within the vehicle.
And to your question, again,
thank you.
We're going to be addressing video identification in public access space in the September meeting. Where it applies to law enforcement contexts, particularly where you've got facial recognition technology that's saying, hey, we're monitoring an intersection, and this guy who we've been looking for drove through this intersection. We caught his face through visual recognition, and it matched some data. That would apply to a law enforcement application. So that would be on topic for today. The general public space discussion, I think we're going to have in September. And I'd like to maybe address that issue when you're about ready to wrap up, Mr. Keller, if we could.
Okay.
I just want to get back to that. I don't want to throw you off step.
But, you won't throw me off. The other thing and this is more policy related, because we and I'm going to talk about DNA a little bit more. But when we start talking about the confidentiality of our DNA database, I think is pretty well statutorily grounded. I think we've got some safeguards. I think an area that of concern would be in your private sector basis, and that is what information can a private sector gather, and then what happens to that database? And I think it's a situation, what do I have to give up in order to qualify for that loan? What do I have to give up in order to qualify for certain things? And then if I do, then what have I given up? Do I give it up just to that company? Or what kind of situation does that company, then have? What kind of responsibility does that company have? What kind of responsibility does that company have to other companies? What kind of responsibilities does that company have to governmental agencies? And we've got the situation, and I think this is something on a national level, dealing with phone records, and that is a situation where in the name of battling terrorism, I think Southern Bell South or those gave up phone records. Now, they did it through a consent. Now, one of the things that you're going to hear about with protections, when you're talking in terms of protections, you're talking about your Fourth Amendment protections. And there are certain things that I can't get unless I have probable cause. However, I can get them if you voluntarily consent to giving them to me. Well, that is an individual situation. Chairman Sessler, I need such and such and such and such. Will you give it? Sure, Bob, I'll give it to you. Or, Bob, unless you've got some legal basis against it, you're not getting it. And then I have to, within the Fourth Amendment protections, come up with a basis of doing it. Well, what if Chairman Sessler gave to Bank of America this information, and I, as a governmental agency, go to Bank of America and I say, I want all the information on Chairman Sessler. Sure, we'll be more than happy to comply. What expectation of privacy does he have? Now, the problem is, it's one thing if you're saying, well, then it's a consent. It's a consent from that party to the government. And what standard should the government be held to in order to get it? Does the government need to have probable cause? Well, your first reaction would be, well, the government needs some basis of requesting it, and it needs to be more than consent. But then at the same time, let's suppose Bank of America and Wachovia get together, and they don't do anything. They decide, I'll give you mine, you give me yours. And so you've got a situation where two private entities commingle, and there is no security between those two privates. Yet if government needs it for governmental interests, they're held to a higher standard than private are held between private and private, if you understand what I'm saying. So what I would ask this commission to do, or this study committee to do, when you're looking at the protections, that we don't hold government to a higher standard than we hold the private sector to in this exchange of information. If we're going to protect the individual, that you protect the individual from other private sector concerns, as opposed to just protecting the individual from what I would consider a governmental concern. Because and the one thing that when we were doing our research, you've got the probable cause expectations and the probable cause requirements. But when you're talking about that big old word called consent and agreement, if two private companies can enter into an agreement, we're going to give all of your information to you, all of your information to you, then you've got a whole, then what about the private person who said, I don't want Wachovia to have it. I gave it to Bank of America, but I do not want Wachovia to have it. And then does the private individual have to give up anything in order for Bank of America to even listen to that private individual? Or is it going to be a situation where if you want this loan, you will give us all of this, and we have the right to do to anything we want to do with that information? So here again, I have no solution to that. I just bring it up from a prosecution standpoint and a protection of society. Let's don't erode society's protection, if there is a situation where the individual is not being protected, in that private sector.
I'd like to revisit that hypothetical scenario that you just gave us, to where, so Bank of America, I believe, I've been told, I don't bank with Bank of America, but in some cases requires fingerprint to do business at some of the banks. If that information or other information or privacy information that you that the consumer has consented to give up that information to Bank of America, that consent is for them to give it to Bank of America, as you stated. In the situation to where that government then requests that information of me and I deny it, is it a legal process that you can then go and get that from Bank of America?
Well, that's
because the consent was given to the bank, not to the government.
Well, that's the question. Can Bank of America consent to a government request versus does Bank of America make the government show a basis of asking for it? In other words, to the extent that we would show that we had probable cause, going through a Fourth Amendment situation through a subpoena, in a legal process, or could we just do it under the color of consent? And that's the interesting question that comes up. And that's something I think is being debated right now on the national level, in the name of security. And I just bring it to your attention that is something that I think this committee would want to look at, and that is a balancing between what this individual has done with Bank of America, and then what does this, what can this individual expect from Bank of America to protect that information? And I don't have a good answer for you.
Well, a question you might have an answer for, legal counsel or someone else in the room, that has the courts, legislature, government ever identified who owns the data? Is that personal information about me, my data, that I own, and I'm only giving access on a temporary basis to Bank of America? Therefore, if they release it, then that equates to theft, because it's something that they did not own, that they are selling or giving to someone else. Has that ever been...
I don't know that when we talk about the biotype information, most of the information from a Bank of America type situation are going to be it's a transactional situation that involves records and involves the non-personal aspect of it, as opposed to what you're asking. And quite candidly, I know of no case now. Now here again, I'll defer to anyone in the room if it has been established, and it might have been even established in a civil type situation scenario as opposed to criminal. On that, and I just don't know that.
I know there's a Supreme Court decision years ago dealing with the fingerprint, is that the decision was, since there was just dealing with an arrest, not a conviction, if someone is suspected, that there was just cause in the fact that they were suspected, that law enforcement or the government could take that information, and part of that decision, whether it was actually spelled out in the decision or it left with the understanding that the fingerprint, that information does belong to the individual. And that might be something to think about with the committee, is the ownership of that privacy information.
Yeah, right now there's no, I couldn't find any statute that specifically addresses this situation, but that could be possibly one way to address it. But at the same time, we should keep in mind that there's no reason why law enforcement shouldn't be able to obtain this information when it's supported by probable cause and through the appropriate legal channels.
So that question, go ahead, Mr. Coates.
No, what were you?
So if, in the context of this bank or this institution we're talking about, currently if they didn't consent, and I'm not clear that they could consent or could not consent, but if they were resistant to giving up this information, but law enforcement wanted it, under current law, through the subpoena process, it could be obtained.
That's correct.
Probable cause, subpoena, get the information. So but it would have to go through those channels and only in that context.
That's correct.
Okay. So the question we need to address is, do ownership of data, and can any biological information, which could be enumerated in certain types, do private entities that have obtained that from folks have the ability to consent with that, or does that belong to the individual that provided it? That's the
question.
We'll make sure we frame that clearly.
And I think it's not just the type, but when you were in the military, I worked in intelligence. You take one piece of information, it might not be classified. But when you combine that with several other pieces of unclassified information, then that becomes dangerous material. It could be that name and address is not necessarily information that the person might be considered to own or dangerous, but when combined with social security number and other information, then you could be looking at a problem. So just my thought process as we're going is, we might say, well, yeah, when it comes to DNA, fingerprint, those facial features or whatever, that is owned by that person. I think we have to look beyond that, is at what point is information that is improperly released violate the privacy of that individual. But I appreciate your point dealing with the between businesses. We tend to hesitate to regulate industry as much as I believe the Founding Fathers intended us to regulate government more than we do the private industry in certain instances. But I think you bring up a very valid point in what could the transaction that could happen between two private institutions, and I think it's something we do have to take a look at.
Well, that's the one thing, and here again, and I was kidding, but I was also serious. I mean, this is a situation where just back in 1983, we never thought about DNA. And so now look at DNA. With the advent of CSI and some of these shows, there's an expectation that there should be an identifying mark to solve every crime, and that it can be gotten off everything. I am amazed at some of the ways they get it on TV. I hadn't gotten them like that, but it's amazing how you can get it. But here again, no one thought about what now is demanded of individuals in our society from this bio situation, because we have become so technologically advanced. When you can go to a computer and type in a name of anything and Google it, they say, my goodness, what information highway is now available. So it is something that, like you say, I don't have the answer to, but it's something we really need to look at, and I commend this. Sort of to get back to the DNA and to get back to some of the things that I think this study committee will be looking at, and that is looking at the DNA database and whether or not there needs to be an expansion or not expansion. And at a situation, there are about 7 states now that authorize the collection of various categories of arrestees. California, Kansas, and Louisiana all have felony arrestees. Minnesota, New Mexico, Texas, and Virginia have other aspects of it, and then I think about 44 states deal with the collecting it from felons as it relates, the convicted aspects of it. Where does Georgia need to be in a situation like that? And if we look at a little sheet, and if you look at some of the categories that we've got, you've got arrest of a misdemeanor. That's something that is punishable by less than up to $1,000, up to 12 months in jail.
Mr. Keller?
Yes.
To that point, the other context, New Mexico, I think Texas and Virginia, you said?
Right.
What are any of those, what I'll call context, shy of felony, or are they beyond felony, i.e. incarceration?
I think that these are, I think I think that, unfortunately, and I don't have I will get better data for you on this. I think some of these are felonies. I think some of these are in addition to felonies.
Okay.
I think with the various categories, there could be misdemeanors also involved.
And when you said, and again, you may not be able to speak to this immediately, but California, Kansas, Louisiana, are those arrest for felonies as a procedural thing? Are those convictions?
No, this is arrest. These 7 states have varying degrees of collection for the arrestee situation. Okay. So as soon as that person's arrested, no conviction, no anything, it's almost like we do fingerprints now.
It's a procedural thing, yeah.
It's a procedural situation. If you're booked into a jail, you are fingerprinted from an identification standpoint. So if you're booked in, or if you are arrested, and this would be different from the citation, where you're just ticketed and told to have a nice day and appear in court on your summons. But if you're actually arrested, then those 7 states have some degree, and I will get that for the committee.
And this is where I'll need you to educate me briefly, and maybe some members of the committee, on criminal procedure, which I'm still learning. I have a real steep learning curve still. From the stop, whether it's a traffic stop or whether you stop a car because you've got probable cause that there's drugs involved or whatever, all the way through, as you said, booking somebody in jail, unpacking that issue and focusing down within that. Where would the line be drawn from, okay, the cop stopped people, the cop took folks down to the station, say took a group of 6 or 8 people down to the station, but upon further questioning, 3 or 4 people just weren't seen as being worthy of being charged. They were just released because after questioning them, it didn't seem they were related to the crime at all, and they were released. Were those folks that were then released, would they consider to have been arrested? Well, would a charge have to follow?
If you have a restriction of your freedom,
okay,
then that's going to be a legal arrest.
Okay.
Now, we don't think of it in terms of, when we normally think in terms of arrest, Okay. We think in terms of somebody who is taken to a jail and booked in.
Right.
But for your legal constitutional protections, if I restrict your freedom, if you cannot leave, and I make you stay, then you are, quote, for those purposes, arrested. Okay. Now, for your criminal procedure purposes, what would normally happen is, and we've got a chief here, and he can verify this. But if one of his detectives, for instance, they stopped 6 people, and they, quote, arrested them in the sense that they took them to the station, and upon further questioning, 4 of those people were then told you can leave, then you will probably see their names in reports.
Blotter.
In the investigative report, because 2 of those people were then subsequently booked into the jail and arrested for the robbery. And the other 4 people that were questioned, their names are going to be contained in the report, and their degree of culpability is also going to be stated. But you're not going to see them from a fingerprint standpoint. They did not reach that. But they were, in the sense that their freedom was restricted, they were arrested from a legal standpoint.
No. Given that definition and given your understanding of what some of these states may be doing, I'm trying to get my mind around in that circumstance. The 6 folks that were brought down to the station, 4 were released, 2 were booked into jail. With the 4 folks that were brought down to the station, having been placed under arrest, would they be subject to DNA being collected, fingerprints?
No. I'm using that arrest, unfortunately, just from a legal standpoint, to show that they would have certain things would have to be. For instance, if they were brought down and arrested, then there would be a requirement before they could be questioned that there would be rights advised. Certain that their status would trigger certain protections. But now, for your purposes of DNA, and for the purposes of these 7 states, when it says arrestees, those arrestees are those that I would suspect are actually being booked into the jail. They are not convicted.
Would you call that charged? I'll recognize your question, but I don't know. I'm trying to find the term of art for. I'm taken down to the station. That's pre-charge.
I really think that you can almost use the term for the common understanding. The term arrest is what you would really use. That if you're arrested, because if I asked 10 people, what does it mean arrested? Man, they took me to jail. Anything that involves taking me to jail, they're going to say I was arrested. So I think for this, I think if you use the term arrest, you're using it versus conviction, and I think that would be I don't think we need to get into the charged or not charged. I think arrest is going to be the better word for that.
Well, not that I can ever modify something that I think Bob Keller would say, but hopefully shed a little light in the sense that our courts have embraced the distinction between a full custodial arrest versus a detention. And a detention is seen as something that is somewhat shy of a formal charging decision by either the arresting officer or some prosecutor who either files an accusation or seeks some sort of indictment. But there is a distinction out there that is currently in the law between a detention, which may very well be an arresting of your freedom of movement, but you have not been formally charged, formally declared to be subject to probable cause and that sort of thing. That might be a little illuminating.
That's the distinction I'm looking for. Is there any information that is required to be given upon detention? I mean, for purposes of identification, for any purpose, do you relinquish any information of that? I mean, do they take a photo of you? Do they take your prints? I mean, because again, I think about, and again, as you think through some potential hypotheticals, I can imagine being a guy serving in the military with us, walking down the street to his mom's house in Washington, D.C., and all of a sudden he was in the midst of a crime scene. There was a gang shooting. People were dead and bleeding right next to him. He ran and grabbed a guy and was caught up in the scene. Well, the cops came and detained a number of folks, brought him down to the station to begin to unpack what happened. He was detained. He was an innocent guy, and that was established. But would he have relinquished any information, having been an innocent bystander involved at a scene of a crime? And that's
very quickly, because I don't want to take up time here, but we have 40 or more years of history in this. If you look at organized crime investigations, identification, photographs, matching up of names and faces, people who they associate with, activities they may or may not have been involved with. Here, more contemporarily, in the past 20 years, gang books, any person who, we have very comprehensive gang prosecution language in our code now that talks about persons who associate with one another, wear identifying colors or tattoos or other markings. And certainly there are officers, and this is commonplace practice, I think all of us are familiar with this, you see it on the television news, where officers out conducting field investigation, shy of a charging decision, but having identified individuals who fit that criteria, taking photographs, conducting third-tier citizen police officer encounters where they ask for information like your name, who you identify yourself with, and of course those individuals don't necessarily have to give that information because they are shy of arrest, but to the extent that they proffer that information, it's going to be recorded, it's going to be put in a database, and they certainly will have their picture taken, may or may not be with their consent. It has to be compiled.
Just adding to what Kim says, I don't think it isn't going to involve fingerprinting. I think the most it will involve, other than a question answer. Let me see. Show me some identification, which would be producing a ID card, producing a driver's license, so that the person knows who that person is, and maybe the photograph that for purchase. But I don't know of anything where they would be doing without something else, without other probable cause, there would be any type of fingerprints or any other type of identifying.
I want to recommend, did you still have something to add?
Well, Mr. Chairman, I just want to throw this out. There are only 7 states that are not doing this, and the reason is this is a fairly new allowance that was made under the DNA Fingerprint Act signed this year. It was just signed in January of 2006 by President Bush, that would allow for collection of arrestees or those charged in indictment. It is still up to the state to come up with their own statutes on how to do that and how they plan to collect for that. Of course, funding also comes into play. That's why they're still on the 7. Louisiana, I do know they have live scan instruments now in their booking station. So when someone comes in, the live scan fingerprint, that's checked, and if they're already in the system, they go back, and when they're arrested, they collect the sample.
So again, I talk about casting a broad net. If on a crime scene a number of folks are brought down to the station for questioning, let's say that one of the 4 people, again, pre-arrest, I don't know if it's pre-charge, I don't know what the appropriate term is, if upon questioning they were found to really not have contributed to the crime and they were going to be released to the street, you're saying in Louisiana there's a back channel check that, having been booked into the station, you can look at other things that might be on the table that they could have committed, and by the fact that they were brought down to the station, found to be innocent in this circumstance, could be linked to something else via the database. That's the issue we're trying to get at. Is
it would be up to that state to define not to collect it.
Okay. And in that context, you're saying it's photometric, photo ID with fingerprint.
Live scan fingerprint, and then they're held, and then when they come back and that's confirmed that is the person.
Okay.
Then they'll take the sample.
Okay. Okay.
I'd like to just take this one step further, a question that I've had, and really two-part. I'd like to go back to Calvin Johnson's situation, but before that, let's take the scenario that Representative Setzler's laid out. Case, hypothetically, I'm arrested, taken in, booked. Our Constitution says I'm innocent until the jury returns and gives a guilty. If I'm correct in that.
That's
that
right.
I retain my innocence.
Or
plead guilty.
Your evidence,
right.
You plead guilty or found guilty. That's correct.
At any point from the point of arrest and I agree, information can, in most cases, should be taken. Constitutionally, the Supreme Court has ruled that we can do that. But if any point from the suspicion of the crime, the arrest, booking, up to the point the jury comes back and let's say the jury determines that I'm innocent, or at any point in there, innocence is determined, what is the retention of that data? And as a citizen, that the Constitution has declared I'm innocent, do I not have a right to return to the equal station that I was in prior to my arrest?
Okay, now you have just hit the mother lode of controversy as to that. Right now, we're going to talk about expungement. Okay? We're going to talk about from an expungement of who else can get it. If you, prior to indictment, prior to anything, don't you just love somebody? It is. This is your code section is 24-4-65, and talking about some of the expungement, and there's some other code sections that deal with just the expungement. If you are not charged, you can make application to have your record expunged, and then it goes through a process. The prosecutor signs off on it, and there is a situation then that the Sheriff's Department and GCIC, and I will let them tell you exactly what they do when they get an order of expungement. But there is a basis of expungement. There is no basis right now for a fact that you, and I had this situation where a person said, I am not guilty. We felt like there was sufficient probable cause to indict. The grand jury indicted. We felt like there was sufficient evidence to prosecute. The person went through a jury trial, and that person was found not guilty. Now, there was no basis to expunge that record. In other words, they went through. That was it. It did. Now, should there have been anything? And I was the prosecutor, and I was trying to figure out a legal way to do it, but the statute did not provide. Because there was evidence that this was, there was not a mistake. The record, the person was arrested for theft. Mm-hmm. The record accurately showed an arrest for theft. The record accurately showed the disposition of the case, not guilty, by jury. So the record was correct. But from a standpoint of expungement and innocence and the right to, did that person have that right? And our statute doesn't provide it. While this is not a situation that really this study committee was designed for, our expungement statute needs to be looked at because there are some very big inequities in it, and I am telling you that from a prosecution standpoint.
I will say this: it is in the I think in the expectations of the committee in our first in our first organizing meeting, not to address expungement holistically, but address the issue of biological data maintained by business, maintained by government in any context.
That would get
and at what point, if it's handed over at some point, what are the circumstances in which it has to be purged and gotten rid of and so forth? So that would tie in.
The last thing that I just wanted to say, and I wanted to talk about, and I'll just be very brief, and then I'll see if that representative get back to you, that question you might have had on that, is the DNA and where we're going. I don't know that if we look at the Georgia's history, Georgia's inclination, I don't think we're going to the ID card. I don't see that happening. I think you've got a balancing, however, from a fraudulent standpoint on how much you can collect and how much you should collect. I think you look very carefully, though, at our DNA bank, and I think you look at the benefits of having the collected the collected evidence from the convicted felon situation, and then you look at whether or not there is there a balancing of individual versus the policy decision for the protection of our society, and then you look at what else you should collect. Now, we hear about what 7 states might be doing about arrestees. We still, in Georgia, are not even collecting it on convictions, on all convictions. We are not collecting it on convictions that do not involve incarceration. Now, when you look at it, and I will, the balancing is, is there a reason to do it? All felonies involve a lot of non-violent acts, and do you need to collect DNA on theft by shoplifting? And that's a question. And so instead of saying all felony convictions, should it be all felony convictions that involve crimes against people? But that result in probation as opposed to incarceration. Those are policy decisions that this committee should, I think this studies committee should look at. And you don't even in Georgia, there seems to be some middle ground before we even get to the pre-conviction aspect, which will be the more troublesome situations because it could involve the person, the retention of evidence against a person that has not even been found guilty. And so, since Georgia just does it on incarcerated felons and doesn't even do it on all felons that are convicted, you might want to look at that. You've also got convicted misdemeanors, and do you do it to all misdemeanors, or do you do it to those that are of a high and aggravated nature? Do you do it with those that here again involve something that deals with the potential of violence that could then affect the protection of society? If I am a repeat domestic violence batterer or thing, and I am convicted of several misdemeanors, should you collect my DNA as opposed to somebody that is a habitual speeder, that just keeps running that red light or keeps speeding? And is that, in balance in that? With that, let me just say that from a prosecution standpoint, we want to work with you. We again think this is now that I figured out what you're doing, I'm fascinated by it, and look forward to learning a whole bunch about it and everything. And
so are we.
Thank you very much for letting us come.
I just
Before you go, Bob, on this expungement issue, that's something that I'm very concerned about. I want to work with you.
Okay.
Why shouldn't we just automatically have a statute that expunges records if you're found innocent or not guilty? Why shouldn't we just clean the records up and expunge them?
Well, I don't have a good answer to tell you why we don't. What our records have been, what we were more concerned about, and one of the things that you're going to hear from the Georgia Bureau of Investigation is they are still working with records that aren't accurate, that they can't get contributing. And this happened a lot. I think I had people come in and say, Mr. Keller, I went for a job interview, and they told me that I had a record. And I said, well, do you have a record? Well, 20 years ago or 10 years ago, I wrote a bad check. And I went to the magistrate court, but I paid it off. And I said, well, give me permission. And I just did this. I said, give me permission to run your record. I didn't charge him any money. Give me permission to run your record, and let me see what I got. Well, lo and behold, I'm sitting there, and I run their record, and it shows bad check. Nothing else. It shows arrest, bad check. There weren't even a record. There weren't records of it. So I would write a letter, trying to get the record even accurate. So if you're, we've talked about having accurate records, then we talk about, the situation of if they're found, they're found innocent. Now, I don't want to get into a situation if you're found innocent, are you really innocent?
Right.
That's an argument for another day, but it is an argument from an expungement. Should there ever be a record of the fact that you actually were arrested and that you were tried? And should that record adequately reflect what happened? Not guilty. And does there need to be a record? Law enforcement might say we need to know a person that has been arrested like that, but does Bank of America need to know that for employment purposes? Does Bank of America need to know that for offering you a loan? Or is that something that, is it your individual thing versus that? And that's the reason you have not seen a statute, Representative Brooks, and you've been around a long time. That's the reason that statute has not just said if you're innocent, you're expunged, or if that charge is dismissed. It's time to revisit it, though. It is time to revisit it, especially on dismissals and things that don't even come to these. And right now the onus is on that person. And when we were working with juveniles, and we were trying to figure out what to do with juveniles after 3 years, they can, after they reach a certain age, things can be expunged. And the concern is, do they know how to do that? Do they know? No, and they don't. And the answer is they do not. That is correct. And then It can be, and depending on who does it and whether you've got $25, and that should be something that that is something from a societal standpoint that we need to address.
Let me just give you one case. There's a young man who's in law enforcement from my home area.
Mm-hmm.
And he had a misdemeanor conviction a long time ago. He was a young man. He was a deputy sheriff. He wanted to apply for an own position. When he made application, he had to say that he had a misdemeanor. And he wanted to know what he could do. We actually had to get the DA in the circuit to work with him to get a private law. Take this case back before the judge in Wilkes County, the heard case of this misdemeanor. And the judge had to sign an order in order to expose his record, to get that off his record in order to get another job. So a lot of persons who want to come into law enforcement and who want to move to another jurisdiction, they have this issue of clearing their records to move on. And so this is fun. It's really something that we really need to do. It's affecting a lot of people.
It does, and the other thing about it is, you're lucky in a rural area that you still got the same, you've got some history, so that same judge will do it. You've got a situation in the more the metro area where judges change, prosecutors change, and I don't know what happened. I'm not about to touch this because, man, that happened before my time, and I'm not going to do it.
Actually, the same expungement procedure is pretty uniform across all jurisdictions. And that makes me think there's probably some sort of legal reason to do it that way. It's something that would definitely be worth researching. But like I'm just saying, everybody, uses the same procedures. So
it is. We've got one right now, and there's this kid can't get a good job, and you also at 59 you do things, and so I called an attorney and I said, you are going to represent this guy. Well, am I going to charge him, Bob? No, you're not going to charge him. Well, why should I do this? Well, because I asked you to, and he's going to take care of it, and he's going to walk him through it, and it's just some kid that just deserves a break, and you just thank you again. Based on we talked about, you had one of your members couldn't be there. I've got a doctor's appointment at 12:30 that I've got to take care of. So yeah, it is. I'm fine, but I just wanted to tell you I'm not going to be here with you this afternoon. But thank you again for letting us come.
And if you have some more questions, you can ask me.
Yeah, but anyway, we'll. Oh, what time is it now? Oh, I'm fine. I can get there. They're not going to be on time. But I'm gonna leave. I want to wait. I might leave closer to about quarter till or 10 to do that. Sure.
Cooper, did you have any questions?
Oh, sure. Oh, you want me to sit here? Oh, I thought you had somebody else. No, that's fine.
No. I want to understand, and I think we've addressed the DNA thing fairly well, just for the edification of the committee, to kind of put in context. We talked about certain things that are procedural, and then certain things that are collected based on probable cause that are more evidentiary. Procedurally, for misdemeanor arrests, when you're going to actually book someone, or felony arrest, is there any difference in what's collected from people and what is typically collected? I mean, typically we see, against, the mugshot and the fingerprint. What is typically collected in those in arrest and as you kind of move through the system? Just to kind of provide a context.
Let's forget the crime. Let's just say misdemeanor, or you're being booked into the jail and you're going to have to bond out. You're going to have to go through it. They're going to take your fingerprints. They're going to take your mugshot, and that's going to be it. They're right now. They're not taking DNA. They're not taking anything else from the standpoint of that. Now, any other evidence collection is going to be doing pursuant to either consent as it relates to something that was, if you were, that was part of your arrest prior to even getting to the jail, like searching your car. If they're going to take hair, are they going to take blood? Are they going to take, now we won't get into the implied consent as far as the driving, but if they want to take something for the investigation of the crime, on a felony arrest, they're either going to have your consent or they're going to have a search warrant.
And that's clearly established, no questions.
That is clearly established. But now, if you're being arrested and booked into the jail, they're going to take your fingerprint, they're going to take your mugshot, whether you're a felon or whether you're a misdemeanor.
Well, philosophically, you can get at, is that because they're just trying to identify you? And it's more of an identification thing than an evidentiary.
It is an identification issue to make sure you are who you are. Now, the other thing that happens, too, is when they identify you, there's also a situation that, depending on who you are, there might be a bench warrant out for your arrest. There might be another warrant from another state, another county, showing that you escaped from or that you're being wanted. And so that identification then puts you in a position then to be exposed to something else if you have, if you've been accused of that. But it's strictly it is strictly to make sure that that if you say, I am Robert E. Keller, that you are in fact based on the fingerprint identification, and that now they'll ask your Social Security number, which will also help them. Your date of birth, date of birth, Social Security number, photograph, fingerprint.
And again, that is an identification thing. We understand being able to run cross checks. And I think everyone understands the importance of that. The question is, although that's the fingerprint and the photo are collected for identification purposes, that fingerprint then can be run in can be cross-checked to see if those prints get a hit on some other crime scene. So and that same fingerprint collected pre-probable cause, but for purposes of identification, can still be used in an evidential way in the same case or in some other case, can it not?
Well, evidentially, that fingerprint could be used to show that the person we booked in owned that fingerprint. And so if there are fingerprints that are collected at the scene of a crime, those fingerprints can be compared to what we call the known fingerprint. The known fingerprint of Robert E. Keller, when he was booked into jail, is compared to these 4 fingerprints that were left at a particular scene of crime, and therefore it would be used. That's the evidentiary way that it would be used.
Okay, so the discussion is, and I think this is something we need to, it's a policy decision we need to get our mind around, which seems to be, I'm making some assumptions, it seems to be where California's going is, they're taking the DNA to say, this is just a more certain way of identifying you. It's a 21st century fingerprint, as it were. But again, that can also be run and cross-check against other crimes and make that link. So it's being done now with a fingerprint. The question is, from a policy standpoint, although it's not collected in the context of probable cause, it's an identification thing, it can still be used in a way that, in effect, can tie you to other crimes. That's the policy thing I think we've got to deal with. But I wanted to make sure it's just limited to photo fingerprint now.
Right.
And hair, blood, urine, any of those things are purely probable cause driven.
Probable cause driven.
Okay.
And I think follow on with that is the way that these other states are going and the current problems we have with our expungement, then we might be treading on dangerous territory. If we had our expungement laws to where if we were brought in for questioning, let go. Yeah, obviously you had nothing to do with your innocent bystander. And we knew our records were going to be expunged at that. That might be an area that we look at expanding into. Okay, do you take an identification of someone on a misdemeanor? But I'm afraid to kind of tread into expanding what we're doing right now. Learning what I have learned today dealing with expungement is that that's going to be on record forever unless I just happen to know that I need to go ask for it to be taken off. If I do, let's say I was at any point from the arrest on found innocent either through lack of evidence or absolutely cleared through the evidence or up to a jury saying I'm innocent, and I request records to be expunged, is there any reason that my request is denied, or will that have to be expunged upon my request?
If your jury finds you not guilty,
right?
No, you cannot. The statute does not provide for an expungement in that situation.
Other than that, If I request to be
up to a
exposed, do they
point,
have to expose?
up to a point, you can.
Okay.
And we've done it. Now, here again, you have to request it, but the case comes in to the district attorney's office, and the case that we're talking about right now is a murder case. The case that I'm trying to help this
Right.
young man on is a murder case where he was charged with the offense of murder, and it never went anywhere. It never was indicted. The district attorney's office said there was insufficient evidence to prosecute.
Right.
But it was not expunged, in the sense of taking care. And so the onus is on him. Now, if you'd already gotten to an indictment situation, then you're talking about a different situation.
Does the expungement also go as far as not? I'm thinking of this as a record. In the scenarios we talked about, where just brought in question, and DNA fingerprint is taken, those records are kept.
Well,
Or that information, or is it just used to identify me and there's no record kept at all?
No, it's no record. I mean, that's the thing. If you're just brought in and in your scenario where 6 people go to the police station, 2 of them end up going to jail, 4 of them go home. The 4 that go home, other than asking you who you are, and for identification, making sure that I call you the right name when I'm correct, there's not going to be any retention of that.
So
none of that. I mean, you're not going to be talking. You're not going to be fingerprinted. You're not going to have now. What Ms. Kimbrough was talking about, if it was a gang situation, they might take your photograph and keep it in a little thing, but they're not going to keep anything. They're not going to have. You're not going to have any other record.
I just wanted to clarify that when we're talking about taking fingerprints and taking DNA samples, what we really need to keep an eye on is like constitutional protections and whether the obtaining of this evidence satisfied constitutional requirements. Like when they take your fingerprint, did they have probable cause to take it and satisfy the 4th Amendment? Well, okay, yes, they did. Then they have a right to have access to your fingerprint. And I also wanted to clarify, since we've been talking about all this stuff about DNA samples taken upon arrest and stuff, I just wanted to clarify that in Georgia, the no sample goes into the DNA database until after conviction. So that means we satisfy, before you end up in there, we satisfy not only the 4th Amendment, 5th Amendment, the 6th Amendment, 14th Amendment, like any constitutional amendment that must be complied with to get a criminal conviction. And a criminal conviction is the strongest statement of guilt that is available in the law, and we required that before we'll put anyone's information in our DNA database. And that actually goes beyond what is required by the Constitution. So I just wanted to point that out.
One quick question. Is DNA information ever collected? I know it sounds silly, but for misdemeanor to prove someone shoplifted or...
Oh, if you got it. Now, I mean, here again, if there is a way of DNA,
simple battery or something like that.
You could. Now, here again, it's a balancing. I mean, you've got a situation like you do a lot of times in the prosecution of a case. The Georgia Crime Lab is woefully understaffed when it comes to how they can do things, and as efficient as they are and as effective as they try to be. If I sent DNA on a shoplifting case, I don't even want to. I won't look at them right now. Okay, I refuse. But the answer would be if you obviously if you could, anything that will remove a doubt in a juror's mind, you want to do that from a prosecution standpoint.
But legally, and again, I don't have the code for me. I don't know if simple battery is a misdemeanor.
It's a misdemeanor.
But in the case of a domestic violence or simple battery or something, if there's hair or something they collected and they wanted to prove it, and for whatever reason they ran it and proved it on me, upon conviction that would then go to the GBI crime lab. No. Upon
conviction, you would. It's a misdemeanor.
Okay.
You would not see. You gave up the DNA
okay.
that was used for your conviction was gotten one of 2 ways.
Okay.
Either there was something left at the crime scene.
Okay.
And then based on that, we then got your DNA through a constitutional allowable way. You either consented or we used a search warrant to get DNA, and we compared your known DNA with what we had at the crime scene. That is the only DNA. That DNA right then is evidence that is kept, depending on the retention of after so many years. That evidence would be destroyed after your conviction. Now, once you are sentenced, because it's a misdemeanor, there will be no subsequent DNA collection for our DNA base, even if you are sentenced to jail.
I understand that.
Because it's a misdemeanor.
But the DNA that's collected as evidence in a case upon conviction, let's take a felony case. The DNA that's collected to get a conviction, once the conviction is consummated and complete, and say I'm convicted, that then goes into the
There is
database
and Amy might can help me on this. There is a retention of DNA evidence after conviction, and I don't know how long it is. I don't know whether I don't know whether it depends on it. It either depends on the crime or it's a certain set year, and it might be 10 years, and I don't know what. But there is Amy, isn't it? 10. Okay, 10 years.
Okay.
Is it automatically destroyed after 10 years?
It can be destroyed after 10 years.
Can be.
It can be
usually
destroyed.
It's not.
No, it's not. Normally, here again, especially in a death penalty case or something like that, you're just not going to do something.
This is only upon conviction.
This is 10 years after conviction. Yeah.
I mean, at that point, they've lost their constitutional rights.
My concern is that if in the course of a misdemeanor case, and it may be a misdemeanor of high and aggravated nature or whatever, that if DNA were collected, that upon conviction, it's a policy discussion whether that should go and be maintained long term. Maybe it should be, maybe it shouldn't be. But that's a policy discussion I think we need to have. I think there's a pretty strong precedent for maintaining that for felonies, particularly violent felonies. There's no question about that. I think it'll be a policy discussion for us on the misdemeanor side. I don't know that it's a big deal, but I want to just try and understand where we are.
In misdemeanors, it would be retained, but it wouldn't be retained in the database and compared to others.
The sample would be retained, but it wouldn't be
just in case you need to retest it, but it would not be like in the database that can be run against all these other samples.
Okay, so understand. Gotcha. That being said, thank you so much for coming.
Thank you very much.
Really appreciate your.
Now I'm at the point where I think the doctor's calling. So.
I'm sure the doctor doesn't release any of the record.
He won't release it.
I've
still got a badge, and he doesn't know.
Oh, okay.
I've got 11:46. If it's the pleasure of the committee, can we take a 10-minute break? Again, I had some. I had on the agenda the opportunity for folks to come and speak before Gactel came up and had a chance to present. Is there anybody that's dying to come up and present for 5 minutes and talk? I'd like to go ahead and get Mr. Donaldson going. We might have some folks that want to talk near the end of the session. With that being said, I'd like to call the meeting back into order after lunch. Again, Mr. Donaldson, I appreciate you guys providing lunch for us today as well. And with no further ado, I'd like to turn it over to you.
Thank you, Chairman. Pardon? Turn it on? I think it may be on. First of all, I was very glad to follow Bob this morning. I wasn't sure what I was going to talk about when I came, and he gave us an awful lot to discuss, and your questions and his answers. I wanted to address something I really didn't plan to address early on, and that's the issue of expungement. And I think it's going to be very important in this context. It's very important in the context of what you already have in the law. And I want to address a young man by the name of Steve Donaldson, my son, who's 30 years of age, who's in the finance business in Atlanta and is right successful. And he's a smart young man. When he was 18, he was much smarter. He knew everything there was to know, as most 18-year-olds do. And he got caught up in one of these situations where a number of young men in college were taken down to the police station, and some were arrested and some were turned loose. And he, knowing everything there was to know, didn't realize that he was one to be turned loose until he ran his mouth, saying to the officer, "My daddy's a criminal defense lawyer, and he'll have your badge." He was arrested for obstruction of an officer. Now, I went to Statesboro and met with the prosecutor and the judge, and and we wrote an appropriate letter of apology, and the charges were dropped, and that was an appropriate disposition, and I was not at all offended that they kept him overnight in jail. He went on and got his bachelor's and master's degree in finance, and then applied to become a stockbroker. He's in the federal data bank for an arrest for obstruction of an officer. I had the record expunged. He went to work with another company, which is common in that industry, and I had to go back and get it expunged again. It's still there. And until and unless expungement means something, and it doesn't, in my experience, mean anything at all. I mean, you can have an order of an expungement, but then that's in the record that it was expunged. Then it really is a meaningless exercise. He's been able, because he's got a daddy who is a lawyer, to get court orders each time that he wanted to be like other people. And most of us in college, when we were 18, knew everything we knew there was to know as it was. I mean, had I been in that situation and had my daddy been a lawyer, I probably would have said the same thing. So I think that's an important issue. And the research that I did was not as current as Mr. Keller's, because at the time I did mine and the materials I looked at, there were only 4 states, California, Louisiana, Texas, and Virginia, who tested DNA on arrest. And I understand there is a new statute, and as I understand the way the statute works is that the federal data bank will accept DNA data from any lawfully obtained source, whether it's misdemeanor, felony, or otherwise. Of course, it has not been decided what is lawful. The issue has not gone beyond local courts. And by local, I mean some state jurisdictions have addressed the question of whether it's appropriate to take a sample on arrest. It seems to me that the argument generally raised to support that is that it's no more intrusive than fingerprints, and that fingerprints have traditionally been taken for the purposes of identity, and that when you are arrested, when there's probable cause to arrest you, whether you're Steve Donaldson or not, that you give up some expectation of privacy, and that's the key words when we're dealing with this issue. The problem is it's the privacy in your identity. And one thing that I found interesting, someone here may know differently than me, but I tried to find if the Supreme Court of the United States had ever addressed the question of whether it was an invasion of privacy to take your fingerprints, and the U.S. Supreme Court has not addressed it. I don't think anyone would seriously contest the issue, because when someone is arrested, they may get out on bond, they may not get out on bond, but there's a government interest in making sure that the person that they're taking to trial is the same person that got arrested. And so I don't think anyone would seriously argue that fingerprints should not be taken on arrest. But once you've taken the fingerprints, you've done the identity. You have this person identified. You're not gaining anything by taking a DNA sample. You're not getting any more identity than you already had with the fingerprint. What you're doing is creating an additional basis on which this person can be investigated for the possibility of having committed some other crime, which is not appropriate. I guess if you take it to, because you see, you're innocent until proved guilty. Your rights as a citizen, when you are arrested, are marginally impacted because there's a governmental necessity. If there is probable cause to believe I've committed a crime, then I need to be taken in and either make bond or not, but be answerable. But beyond whatever's necessary to make me answerable to the offense, there's no need to take other private information. Our Bill of Rights, the Fourth Amendment, and the first 10 amendments exist because the framers of the Constitution did not trust the government they just created. They retained rights that they were not going to give to government. To put blind faith in government, with no offense to you gentlemen, is a foolish thing to do. I mean, we need to retain individual rights. We do not need to be in a posture where we trust you to make all of our personal decisions. We need to be in a position to say, you can't have my DNA until I have given up all of my civil rights. And that's the position I think I came to argue here, is that what's the big deal waiting until there's a conviction? What have you lost by waiting until someone is convicted? You know, if you need DNA prior to conviction, if there's probable cause to believe that I've committed some other crime on which there is some or DNA available at the crime scene, you can get, based on probable cause, a judge to sign a warrant to take my DNA. There's no useful purpose for DNA unless there's some probable. There's no useful purpose in taking DNA from someone who's simply been arrested for some offense. Based on you just wanted to have it done. You know, in 65, I think, in Davis versus Mississippi, in Meridian, Mississippi, there was a rape. The victim identified her rapist, the perpetrator, as a young black man. They arrested 75 young black men solely for the purpose of getting fingerprints, until they found the one that was there. And they did find the person. They had a fingerprint there. Now, that's not, there are 74 people there whose rights were seriously violated and whose fingerprints are now, I guess, still on record someplace. They were arrested pretextually. How many people are going to be arrested? And, this goes back to not trusting the government. How many people are going to be arrested so that you can get DNA? You know, just because I'm a little bit suspicious of this fellow may be a pervert or something of that nature. You know, we don't need to just pass feel-good legislation, and we've got a lot of feel-good legislation. Just this past week or the week before, Tom Murphy, former district attorney in DeKalb County, wrote an op-ed in the Atlanta Journal-Constitution attacking the recent legislation, or the legislation that has the 1,000-foot perimeter. You can't have sex offenders within 1,000 feet. Well, nobody thinks that sexual predator is not going to go 1,001 feet if he's going to be a sexual predator. It's feel-good legislation. And what you've done is you've caused perverts to lose their jobs. So now you got unemployed perverts going, who create an even greater threat. You got to think your way through what you're doing with that kind of legislation. Sounds real wonderful. We don't want them within 1,000 feet of our children. Well, you can't do that. Yeah. They can still, you can't keep them from going to church. So according to Mr. Morgan, and I didn't think I'd ever be quoting the district attorney of DeKalb County as a source, but he says the guy can still go to church with your children, sit in the next pew with your children, scope your children out, but he just can't live or work within 1,000 feet of them. That's crazy. Yes. When I start talking, I don't listen. So, our position at GADCL is that there should be no DNA sampling until there is a conviction. And if you look at Justice Scalia's recent opinion in the U.S. Supreme Court, I forget the case, but it's a concurring opinion. He believes that no one is arrested that isn't guilty. I think he's quotes some statistics that we can take issue with, but you're going to end up getting all of the DNA if he's right anyway. You're going to wait until there's a conviction. And that's the criteria, that's the constitutional hurdle. Yeah, we've got a statute, and 7 apparently now, there were 4 states that say you can take it on arrest, but that's untested. And somebody's got to come and look at the court and say, this man, my son, who was arrested for mouthing off at a police officer, has given up his DNA forever into some data bank. It's not going to get expunged. Don't kid yourself about that. And why should you have to petition if you're acquitted to get an expungement? And why should you have to go to the district attorney who prosecuted you and lost the case. I've tried probably 200 felony cases over the years. I have yet to meet a district attorney, and I've won several of them, a lot of them. I've yet to meet a district attorney look me in the eye and say, you know, I never really thought your client was guilty. You know, I prosecuted him just for the exercise because I heard you could try a case. They don't do that. They believe, hopefully they believe my clients are guilty. Hopefully they're not prosecuting a man for any reason other than belief in the guilt of my client. Well, once he's been acquitted and it's up to him to decide whether to expunge the record, that's not realistic. You know, we don't have enough DAs like Bob who don't have some personal ego involved. We don't trust our government, and we shouldn't trust our government. We have no obligation to give up all of our rights to our government. Hopefully we elect people who are who we want in those seats, but we don't have any guarantee. And so we have some rights that we hold dear and that we should not give up. Government gains very little by testing on arrest. If you, and especially if you look at the fact that you're going to have to, as all four of the states that I had looked at, and I suspect the other three as well, have an expungement procedure on acquittal or upon dismissal. But why should anybody have to go through that? Why don't you just wait until you're convicted and take the DNA and then run the case?
I have a question for you. I'm going to ask you to share your opinion a minute, and it'll be just your opinion if you choose to share it. But
sure.
Or maybe you can enlighten me through some factual means. But I'm hearing you say that, I just want to restate what I think I've heard, is that, as we discussed earlier, photograph, fingerprint identifies the person definitively.
Sure.
Fingerprint is an indelible biological marker.
Absolutely.
So to take the next step to go to collect DNA under the name of identification, in effect becomes a unlawful Fourth Amendment search. Is that what you're suggesting?
That's what I say. And, you know, the Supreme Court hadn't agreed with me on many things, and I think they may agree with me on that. There is a governmental interest, a legitimate governmental interest in identifying the person that's arrested. No one's going to quarrel with that. But that governmental interest is satisfied with the fingerprint. That interest disappears once it's been satisfied. There's no need at that point to collect DNA evidence to accomplish what arguably you already have. I don't know that anybody is going to say that fingerprints aren't reliable. You know, and if they are not reliable, if DNA is more reliable than fingerprints, then let's get rid of fingerprints and just do DNA. I mean, no one's going to argue that position. They want both. You know, and it feels good to say, you know, we're going to collect things from arrestees. We're going to make ourselves. There's no difference between a person who's arrested and presumed innocent until proved guilty than there is to my grandbaby that was born earlier this year. You know, it's just simply go ahead and collect DNA on birth, and then we get into all sorts of questions about biblical references and mark of the beast and things of that nature. So I don't think we want to go there. I don't think we want everybody's DNA, but there's no reason to draw a line between someone who is innocent until proved guilty and my grandchild. You know, either you take the DNA or you don't before conviction. But if you're going to take it before conviction, then take everybody's.
Let me make sure I understand something you had said in there. It's on. Your opposition is for that you're stating is taking the DNA for identification purposes on arrest. But did I understand you say that if it's for investigative purposes, where there has been probable cause established, then you're not opposed to the
well, the law's clear
DNA.
about that.
Okay.
You go, if you think this man that you've arrested has committed some other crime unrelated to the crime that's here, but you have probable cause to believe it, and at that other crime scene there is some DNA, not many judges in this state that won't sign a warrant
Right.
authorizing you to do the search, to take the DNA sample, and that's as it should be.
Or even related to the crime that you were arrested
Or related
for.
to the crime that you were arrested for. I mean, I was trying to take it to a broader context. If you have probable cause to get DNA, then you can get a search
I thought
warrant.
you had said that.
Yeah.
I just wanted to
And
clarify that.
So,
that was
so
your position.
our position and my position is that the state really loses nothing by waiting until conviction. Now, conviction for what? Those are policy decisions you guys have got to make. Do you need DNA from someone who's committed a nonviolent crime? If you've got somebody who's embezzled money and has committed that felony, is there any probability that person's also a sexual deviant or doing? That's a policy decision for you guys to make. You want to do it across the board for all felonies, fine. There is some question about misdemeanors in my mind, and that's not as easy a line to draw for me. When you and of course you guys are the ones who define what's a misdemeanor and what's a felony. You're the ones who are entrusted with that. What punishment you're going to dole out for what offense. There was, and it changes. That line changes from time to time. When I started practicing law, if you had any marijuana, it was a felony. Now you can have up to an ounce, and it's a misdemeanor. And so, but there is a big distinction between being convicted of a felony and being convicted of a misdemeanor. And you're convicted of a misdemeanor, you can still vote, you can still run for public office, you still can possess a firearm. You don't give up your civil rights, and that's the biggest difference. To me, the biggest difference is you retain civil rights. You don't lose that. And if you want to, and I think you probably have the authority to decide how much in terms of civil rights people convicted of misdemeanors are going to have to give up. And it would seem to me that there would be some misdemeanors for which you would want on conviction to collect DNA. Violent crimes. There are some sexual offenses that are misdemeanors. That type of thing. That's for you guys to decide. That's not my call. I don't think that's a constitutional issue. Because you make that decision. That's a legislative issue. But to me, it's a constitutional issue if you're going to take DNA from someone who has not been convicted. And I think that's essentially our position.
I have a question for you, if I could.
Sure.
It strays from DNA, but it gets to the question of what some would call an unlawful Fourth Amendment search. And I look at it, I talk in terms of photo. I don't mean just booking somebody when they're arrested, but and we'll address this some in our next meeting in September. But I wanted to get your thoughts on it. Is using photographs to use photometric identifiers to identify, for example, in a sports stadium. Would it be an unlawful? Could you make a defense as a defense attorney if someone were arrested entering a sports stadium during a Georgia football game? I won't use Georgia. Let's say the Georgia Dome during a professional football game, bowl game or something, that was scanning folks as they were coming through the entrance and comparing each person one versus a subset of N, some million faces they had on some scan. They were trying to track down a known terrorist or try to track down somebody who was wanted, and someone was triggered on, hey, this guy right there, that's him, he matches this name in the database the folks were looking for, and an arrest were made. Is walking into a public place like that and having a photograph taken, would that in your mind fall into the category of unlawful search, or is that
to have your photograph taken? I don't think so. I don't think that's an unlawful search. I mean, could I make a defense as a defense attorney? I probably could come up with something, but I don't think that it would be a successful defense. Bob Keller talked about reasonable expectation of privacy. I mean, when I walk the streets of Atlanta, when I go to a sports event, my face is, I assume my face is uncovered. If my face is uncovered, I have no reasonable expectation in whether I'm recognized or not recognized. in my mind, the technology you use to recognize me is just fair game. If I'm worried about it, then I ought to wear sunglasses, and then I might have some expectation. You might have a problem if you have somebody go up and rip the sunglasses off of me, and then you take a picture. But no, I don't have an issue with that. Now, I assume that you would have some basis on which to compare that photograph with some known terrorist photograph or whoever it is you're after. But no, I don't think that the Constitution would prohibit that.
Just a question, just the thought I had, and you could answer this question, is there any constitutional measure about frisking, for lack of a better term?
Yeah, it's Terry versus Ohio, and there's some interesting material that I did look up. 2004 case. And I'll just leave this with you. It's Hibel, Hiibel versus 6th Judicial District Court of Nevada. And in Nevada, they had a statute that has been tested in various versions constitutionally about whether you have to give up, whether you have to tell a police officer who you are. If he has a legitimate reason to stop you, and there are, the magic word is not probable cause, it's articulable suspicion. If there is a reason to stop you and he can explain that to a judge, he can do a momentary detention, and that's not an arrest. There have been several attempts to make it so, and there probably is some legitimate state interest in knowing who the person is that you stop. In California, it was struck down. They had a statute, I believe it was California, I may be wrong, that said that you had to produce credible identification as to who you are. Well, I mean, there's no constitutional requirement to carry a driver's license with you, and the Supreme Court struck that down. Nevada, in the Hibel, and I may have mispronounced the case, basically says that there is if he has a reason to stop you and ask you who you are, you have to tell him who you are. And you see, you've got a threshold there. It's the articulable suspicion. It is, if you can't, the officer can't walk up and down the street and just ask everybody their name. But if there's a reason to ask him his name, then under this statute, of course, you'd have to pass a statute to that effect. And I'll just, I'll hand up a copy of that decision. The key there, and there's some language that I bolded in that case, and it has to do with there needs to be. Let's see if I've written it down. In the context of the Terry stop, that's the Terry versus Ohio. You can insist, constitutionally, you can insist on information from the person that was stopped, but it must be, quote, reasonably related in scope to the circumstances which justified the initial stop. If you have a Terry stop, and the lawyers use those kinds of terms, and I'm sure the GBI uses the same kind of term, just a momentary detention, you can ask for information that is related to the reason that you stopped them. But if you want to go ask for questions, what kind of car do you drive, things that are unrelated to that, and you're just on a fishing expedition, then the citizen doesn't have to give up that information. And if there is no articulable suspicion, if there's no reason to stop, then the citizen doesn't have to give up any information. The line was drawn by the Supreme Court when California, I think it was California, I don't want to blame them for everything that goes wrong in the world, but
that's fine.
They had a statute under which they said you had to present credible verification of who you are. Well, what's that? And what if you don't have anything other than you just walking along in your bathing suit on the beach? It's just giving up information about who you are. I'm Pete Donaldson. That ought to be sufficient. There are, much of what I was prepared to say is not. Bob Keller I was very pleasantly surprised when he presented the district attorney's position here about, they're not trying to create Big Brother. Most of us in the defense bar think that the prosecutors want Big Brother. But I can say that the 2003 position statement goes a lot farther than Bob Keller does, and they've got some criteria about which they want stop on test on arrest. They want
Mr. Donaldson, if you could, I mean, and to your point, if you could outline some of those concerns, and again, I share your regard for Mr. Bob Keller and his organization, but again, we're concerned. We want to make sure that we're looking at and are aware of all the voices out there. And I'd ask early that you take an advocacy position. And as part of that, if you could kind of point to some of the voices that are out there, maybe not in Georgia, but maybe in other places or in the federal level, that we need to consider as we look at this.
Well,
I appreciate that.
Our current administration is pressing legislation like it was passed earlier this year. Now, they don't dictate in that legislation what kind of information can be obtained. Apparently, and I stand to be corrected about that because I haven't read the legislation, but my understanding is that it's is it CODIS, the database that they have, will accept any information that is lawfully obtained, and that whether if it's lawfully obtained from an arrestee as opposed to a convictee and that type of thing. I think it still remains to be seen whether you can lawfully take a DNA sample from someone absent probable cause. If you have probable cause, then you can do it. But absent probable cause, I don't think that there's I don't think it's settled at all that you can take a DNA sample from an arrestee or a mere arrestee. Bob Barr, I read some of the material that he has put out, and he says, aside from the obvious argument that if you arrest a person, photograph them, and take their fingerprints, you already have information sufficient to identify them, and do not really need all the additional information gleaned from DNA samples. Consider the vast universe of persons who would be subject to this intrusive requirement under the Kyle Green legislation if it becomes law, and it may well have, I think that's the statute that became law, and Representative Barr, former Representative Barr, was very concerned about civil liberties, and civil liberties ought not be a partisan issue. Privacy ought not be a partisan issue. Law enforcement ought not be a partisan issue. I mean, we're criminal defense lawyers, but we're not trying to make the streets unsafe. We're not. I'm not here to tell you I want everybody turned loose from prison. I don't. I live in a neighborhood. I don't want crime in my neighborhood. I don't want people who are violent on the streets any more than anyone else does. But I don't want people put in jail and convicted with anything less than the standard of proof required. I forget the name, Calvin Johnson case is an example. And so DNA is a very, very powerful tool, no question about that. I won't argue with my brothers from the GBI when they come here and they say what can be done. The question is not what can be done with DNA, it's what should be done with DNA. I read a piece, a fellow, there was a poet, an American poet, by the name of, I think I've got his name here, Stephen Vincent Benet, in 1935 published something called A Litany to Dictatorship, and he and I've got a copy of it if you want it, but it's a really moving piece, and he's addressing pre-World War II Hitler in Germany. And he talks some in the first person and some in the second person. And at one point, he has a line I really like. He says, "We thought because we had power that we had wisdom." Power and wisdom are not synonymous. Wisdom and knowledge are not synonymous. Yes, DNA can do an awful lot. The question that we need to answer here is, what should it do? What should we be able to do? We can create a database, as I suggested earlier, with every living human being born in the United States, and that you would have an incredibly powerful tool to sort out and make a decision. I would suggest to you that that's every bit as constitutional as testing on arrest. I would suggest to you that you shouldn't do either, that it would become a very dangerous practice, that we would be moving toward the big brother that Bob graciously said the district attorneys don't want.
Let me ask you a question that either your opinion or knowledge that you had, a question I had asked Bob earlier was dealing with the ownership of information.
Well, it's a great question. It really is a great question. Do I own my face when I take it out on the street? I think that to the extent I show it to you, I don't own it. Do I own my DNA? I think I do own it, and I think for you to take it, you have to have a reason to take it. Do I own my fingerprint? I do. But if you arrest me, you've demonstrated a reason to take it. If you arrest me, you have not demonstrated a reason to take my DNA. If you arrest me and suspect that I committed a crime and you have DNA evidence, then you probably can, through the auspices of a judge and a search warrant, get that DNA, and then it belongs to you. There's a line to be crossed, and what your job is, as I understand this committee, is to decide where to draw that line. DNA it's hugely powerful, but it's not wise. It's a science, and you have to exercise the wisdom to make the decision where to put it.
Got a question for you. Well, we've got you, Mr. Donaldson, again. One thing I'd like you to comment on is, and I know it's well established, but trying to understand, and this goes back years, I'm sure, but for purposes of identification, as we talked about before, taking a photograph, taking a fingerprint upon arrest, but the practice of running that against a database that could then hook me and link me into other crimes that were committed where fingerprints were lifted but no one was charged and convicted. That link, which goes beyond identification to using that identification mechanism for evidentiary purposes, could you speak to the constitutionality and how that was established and how that evolved?
That's exactly the reason that I tried to find if the United States Supreme Court had addressed the constitutionality of that. And I database search, there's that word database. I punched in the word fingerprint. In all cases, the United States has only been about 55 cases. The U.S. Supreme Court has used the word fingerprint. And none of those cases have they raised the issue of whether it's appropriate to do exactly what you've suggested. I think there are some state Supreme Courts that have done it and some federal courts of appeals that have. It's such a universal practice. The first time it appears in the U.S. Supreme Court is about 1935, I think, and it was a case where some mobster was trying to hide his fingerprints. It totally unrelated to the issue here. I think the issue becomes moot, Chairman, because it is so ingrained and so accepted, and I don't think anyone would raise the issue of whether it's appropriate to do that. And that does raise the issue when it comes to DNA. I think the argument, if I was the prosecutor and some lawyer wanted to challenge the right to do what you're saying, is that as long as the state lawfully comes in possession of that, and it now owns that fingerprint, that it can do what it jolly well pleases with it in checking other cases. And I think that's what, if I were a prosecutor, I would argue, and if I were the defense attorney in that issue, I really couldn't raise a whole lot of objection to that, primarily because it has been and is so ingrained in what we do, the photograph just as well. I mean, and again, with photograph, I have no problem because that's just what you look like, and that's what you look like on the street. So I think there's a quantum difference between this new technology and the old technology. That you have established identity with the photograph and with the fingerprint, and to the extent it's a legitimate inquiry, you've done that, and there's nothing additional in that scope of legitimate inquiry that you can gain through a DNA search. You can gain a lot of information. But it's no longer in the scope of legitimate inquiry through the DNA. Yes, ma'am.
Just kind of devil's advocate, but I mean,
look at the person, and then photographs were developed, and then you learn how to fingerprint. And as technology has moved forward, we now have the ability, because, to identify us as people. First it was just, you have to look at me. The next is, okay, photograph, and so forth. And now we have this new technology.
Maybe the DNA folks can speak to that, but I don't know what do you gain from DNA in terms of identifying a person that you don't already have from a fingerprint. The district attorney's position, and I can't believe they'd really say this, forensic DNA testing is no more invasive than fingerprinting, yet produces even more accurate results. When you say it produces more accurate results, then have we been they've been telling us that fingerprints are foolproof. It's the gold standard. No two fingerprints are alike. Are they now telling us that there's something more accurate than foolproof? I don't see what you gain with it. And once that governmental interest of identifying the arrestee has been satisfied, then you don't gain anything legitimate. You may gain a lot of information about me when you arrest me. And then that gets into, I got frightened when I listened to some of the things I hadn't even thought about that Bob addressed earlier today about exchanging information in databases. And, it's kind of interesting. I was watching Bill O'Reilly, and some criminal defense lawyers will actually watch Bill O'Reilly. There are not many of us, but they were arguing. They were arguing about this recent wiretap stuff that the president has done, and it's not a government position. Someone who was arguing for the government, but I don't want to say it's a George Bush position, looked and said, the reason we don't go to judges is because we historically are terrible at keeping secrets. That terrified me. That really, really frightened me to think, if that's an administrative position, and I don't suggest that it is, that the administration doesn't trust the judiciary to keep a secret as to what kind of investigation is going on. The more people who know, the more dangerous it is. Well, if you can't keep that secret, then how are you going to keep my DNA secret? How are you not going to share that biological information about me? And then you guys are going to be looking in the civil context that is really frightening. And what insurance company is going to get my DNA? Can they demand, when I apply for insurance, that I give a DNA sample voluntarily? It's a free world. You can contract. We won't contract to give you insurance if you don't give us a DNA sample, and we go see whether you've got all these markers. That's frightening, and I'm really not prepared to speak to that today. But that's something you guys have got to speak to. Yeah, that really is frightening to me, because the other element where you can collect DNA and do whatever you will is when you have consent. And there's a whole body of law, that HIPAA law, that you give information that is protected and you have a reasonable expectation. And there's lots of legislation and litigation about your medical information. But if I say to my insurance company, okay, you can take a DNA sample, and they write a policy based on that, and then they share it with another insurance company, and then they share it with someone else, I hadn't even thought about that riding up here. And when I heard that, I don't envy you your job. I've got some pretty strong opinions, but they're not based on any research. They're just on gut, which is the same thing that I think you guys have probably got.
I have a quick question. This is a question to educate me, and I'm sure the folks from GBI will be able to educate us more on DNA. But when it comes to fingerprint, to actually use a fingerprint to identify someone, that fingerprint had to have already been taken at some point, correct? To
identify in relation to a crime.
Well, no, just to identify that this person is that person.
Yes.
Okay,
Yeah.
There had to be some starting point, either at birth or, in my case, when I entered the military or got my security clearance, that my fingerprint was taken, identified with my name. So they're comparing that pattern of my finger to some existing record already to identify me, correct?
I think we may be on different pages. When I'm arrested,
right.
This is the way I understand identification. I've been arrested. They take my photograph, they take my fingerprint. That's the starting point.
Okay.
They're identifying me If I get out
your association to that finger.
Yeah, I get out on bond and find somebody that looks like me,
right,
and get a few folks to say that's Pete Donaldson. You go arrest him, and the guy doesn't know jack.
Okay.
And he does look like me. They've got no basis on which to compare, and and that's what I understand the identity, the legitimate function of identity.
That was wanting to clarify the identification, because with the DNA, obviously they don't have any starting point already. So okay.
I do have a question for you. It's stepping away from DNA, though, so before I go there, do any other members of the committee want to address any more DNA questions to Mr. Donaldson?
I've got one other point I want to make.
Please
and
go ahead.
That has to do with destruction of samples.
Okay.
And the only thing, and I really don't think I need to make too big a point or be too strident in it, because it really wasn't raised earlier. And that's a question of how long do you keep samples from a crime scene? The district attorneys, the National District Attorneys Association wants the ability to destroy samples from a crime scene. Calvin Johnson is free today and innocent today because Bob Keller, I suspect, was being a little bit humble with you, but he had enough sense to not have that DNA from the crime scene destroyed. I think it was 20 years, and he was proved beyond a reasonable doubt to have not been the perpetrator. If we have this great data storage capacity that the GBI can speak to, there's no reason to ever destroy the DNA from a crime scene. There is within the prosecutorial committee a move afoot to say, and there are statutes around to say, if you don't prove your innocence within a certain amount of time, then tough. You just have to be in prison the rest of your life, because we want finality. And Bob Barr spoke to that in some of his papers, and I'll find it in a minute. He agrees that there must be a high degree of finality to our criminal justice system for it to have the credibility essential to protect society and secure the rights of the accused. That being said, he says, and recognizing that we're not addressing those minority of cases in which the integrity of the prosecutorial process is drawn into question, such cases should and must be dealt with. A moral system of justice must never be so blind or inflexible that it refuses to admit error. And there are, just as there are cases where DNA will solve the case 20 years after the fact, and someone accused of murder is found to have been the murderer 20 years after the fact, there should be no provision that says we get rid of crime scene DNA, because it just might be that DNA might free Calvin Johnson. The Innocence Project, and I don't know the exact number, but it was over 160 people that have been freed from, I think, death row.
Mm-hmm.
That's kind of scary. That 160 people have gone to death row and have been later proved not guilty. And the next question, and that begs the question, and I won't get into death penalty questions here because I've got an opinion that probably doesn't agree with a number of others. How many people have gone the next step beyond death row? How many people are 6 feet under because a DNA sample wasn't available? Some. There are a few. I would agree with Justice Scalia that the vast majority of people arrested are guilty, and he takes that. But you see, the vast majority of people admit their guilt. It's the cases where people contest their guilt. It's the cases where people say, I didn't do it, that we need to be vigilant in. If a man admits to a crime, then you don't need DNA. You don't need it. Well, I guess with John Benet Ramsey you do now, but as a general rule, folks don't admit to crimes they didn't commit. You're looking at maybe 5%, probably less than that, of cases that are actually contested. in the criminal justice system. And if you want to look at those statistics, then the system works reasonably well. But if you were to assume that maybe 5% contest, and half of those, only 2.5% are not guilty, but it's 50% of those where it's contested. I don't know if those are accurate statistics. You know, I have a lot of clients who tell me they're not guilty that I begin to suspect after a while. But, and I have contested a few cases that I wasn't sure of, and I have contested some that I was very sure of and lost, and that's a bad deal. Yes, ma'am.
I have a question, because I'm not a lawyer. I just need to play one in the legislature. I'm a judiciary, which is...
It's not a bad thing to not be a lawyer.
I don't know about that. But anyway, now that we have DNA, is it being used enough that we can move forward and say pretty much as we go forward in the cases, we're less likely to have those mistakes on death row? Or is it used that much?
You know, I don't, well, I'm sure the GBI will take that position, and the DA's Association takes that position. But then, but you beg the question when you say less likely. You know, as long as you're talking about anything other than absolute certainty, there are cases that fall through the cracks, and the innocent should never have the door closed. They should never be precluded from proving their innocence. See, once they're convicted, and the appeals are upheld, and they're serving a sentence, the burden of proof shifts. They have to prove they're not guilty, and that's as it should be, because society has spoken at that point. But the evidence that might exonerate, I'm sure that with DNA, the more that the probability is less, but it's still a probability that those things will happen.
One other question, back just briefly on the expungement issue.
Sure.
In your personal or private or professional opinion, is a person who has been deemed innocent at any point of the process, do they have a constitutional right to return to this same station?
I think absolutely they have that right. Now, you know, the district attorneys want to argue, and again, I'm not talking about Bob Keller, I'm talking about the national position that it ought to be an actual innocence standard. Well, I don't know what an actual innocence standard is. You know, does that mean that I have to prove my innocence in order to be expunged? It would seem to me that once you've had the test, once the jury has looked at you and said not guilty, which doesn't mean innocent, it means there's not enough evidence to convict you, you should have the right to go back to where you were.
But doesn't the Constitution spell out that you are innocent
until proven guilty? Exactly.
And if you weren't proven guilty, then you're still constitutionally
innocent. That's correct. I agree.
Am I misunderstanding?
No, you're exactly on target with that, and said better than I could. I think expungement is a very sore issue with me personally, and with and I can name a number of. I've got a client now who has a grandfather, and he and his grandson were going to the mall in Albany, and he made a left turn in front of a motorcycle, and was charged. And charged with the man didn't die, but he was charged with serious injury by vehicle. They charged him with failing to yield right away, a felony, by the way. And we retained accident reconstruction expert. And we're able to establish that the motorcycle was running around 90 miles an hour in a 45 zone. And the district attorney readily declined to prosecute, but he was indicted. And he now has a record as indicted on a serious injury, on a felony. And something needs to be, that's not within the scope of this committee, I don't think, but something needs to be done to set the record straight for those who are acquitted. And it's really a relatively small percentage, and most folks are so proud to just walk away, they're not going to go rock the boat and try to get the DA to agree to drop the charges. You know, most folks don't have a daddy that's a criminal defense lawyer.
Is that something we can address as a state, or does that indictment work its way up into some federal database?
Once it gets, I think you can address it as a state within the GCIC in the database here. Okay. I don't think you can address it in the federal database, and that's where, because my son was long ago expunged from the Georgia database, but he's still arrested in the federal system.
And we'll be able to ask that question later about when that goes up. Is it what point? If you can keep it from going outside.
He never. I mean, he was accused for less than a week. I mean, we sat down and he signed the letter that I wrote apologizing, and it was.
So when a background check is ran on your son, does that show up?
The arrest shows up today.
Still pops up.
Depends on who runs it. You see, he had to apply for some licenses, some federal securities licenses, in order to get his job. Had he applied for a job that was not that kind of sensitive, it might not have shown up. But the FBI runs those checks, and so it's a very sensitive check in his case. But it's still the same result, and his crime was he ran his mouth, which I suspect those of us who've had 18-year-old sons understand they will do that.
But if the GBI ran the check, it wouldn't show up.
I'm not sure about that. I know that in his case, when he applied for the federal licenses, the FBI ran the check. Now, I don't know. I am suspecting that. Well, I'm satisfied it's not on the GCIC computer. I'm sure that the GBI can access the federal computer. I don't have any doubts about that.
I want to ask him a question in reference to, since we were talking about the fingerprinting and the DNA, what is your association's position on the Real ID? The Real ID, the federal Real ID card,
I don't know
this federal mandate.
I don't know that the association has a position. I think if you read Revelations, there's a position to be taken there. I have real problems with it on a personal level. They say we're not going to be able to buy or sell anything without a number or something. So I think it's a bad
national identification card. Really, that's what it is.
We've got there's a lot of balancing to be done well beyond this committee, and Benjamin Franklin said those who are willing to give up liberty for security are destined to have neither. And there's something to be balanced there. I want some security, but not at the cost of all my liberties. And I'm not sure exactly where to draw that line. I don't like that line drawn on a national ID card. I mean, that sounds an awful lot like Nazi Germany to me, where you get on the train and they want to see your papers. But I'm not here prepared to talk about that.
Well, there's a lot of resistance from certain states, and many members of Congress are having second thoughts about it. I wanted to know if your association.
Well, the association has no position on it. Anything I expressed about it would be personal, and I do have some pretty strong personal feelings about it. I just think it's inappropriate. I think it's wrong. I think it flies in the face of the distrust we all had of government when we set up the Bill of Rights.
Nelson, that was my last question. I think it'll be the last. Actually, I might have two more for you. But I wanted you to speak to, not being a constitutional attorney myself or attorney at all, I wanted to have you speak to the Fourth Amendment and the kinds of things that constitute Fourth Amendment searches, just as a means of context for us as we consider things.
Fourth Amendment reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the key word is unreasonable. Shall not be violated. That's an absolute prohibition against unreasonable searches and seizures. And no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be searched. That's the Fourth Amendment. And that's what the framers of the Constitution wanted protected. Without, if there's no reason for the search, if it's not reasonable, then you can't search. The body of law, and some of it was discussed this morning, the plain view doctrine. You have a right, a police officer pulls me over, has a right to pull me over, I'm speeding, and observes in my car drugs or drug paraphernalia, then it's not unreasonable for him to go into the toilet. But if he just pulls me over because, in the magic word profiling, he doesn't like gray-haired attorney-looking guys riding up and down the road, and wants to look at my trunk. One of the best lines I've ever heard from somebody when he got pulled over, he looked at the officer and he said, "You're not going to look in my trunk, are you?" But in this instance, if he has no reason, no articulable suspicion, no probable cause, he can't, and no permission, he can't go looking in my trunk. He shouldn't be allowed to. But there's a whole body of Fourth Amendment law that I guess we encounter every day. I'm not sure of the specific context, but searching my house, they're pretty much going to have a warrant.
I think I understand probable cause pretty well, fairly well. Working understanding the unreasonable searches piece was what I was going to ask you about. What is that? I mean, could you crystallize that in a sentence or two as to where the dividing line is there? Because we're getting at what is a reasonable intrusion that in other contexts would be a Fourth Amendment search. What's a reasonable intrusion of someone's
There's a body of law about exigent circumstances. There's it's a situation, but for the emergency presented, you would need a warrant. And what is or is not an exigent circumstance justifying a warrantless search is, the Supreme Court reports there'll be 8 or 10 cases every year about that. But there are circumstances under which normally you would have to have a warrant to search someone's house. And if the circumstances are such, if you're chasing a fleeing felon and he runs into a house, you don't have to just stop. The Constitution is a reasonable document, I believe, and it's reasonable to allow the officer to go beyond what he would normally do if it was not an exigent circumstance. Plain view. If an officer is standing, or anyone is standing where they have a right to stand, and that gets into your question about your photographs, and observe something that creates probable cause, then they need to get a warrant at that point. But if it's a circumstance that in a traffic stop, and you see the drug paraphernalia or the drugs or something that gives you probable cause to believe that, then there are circumstances under which the search can be conducted. I don't know that I could possibly draw all the lines and parameters around it because I'm not sure that they're all defined. The appellate courts redraw those lines every year.
What would the basis be in the context of identification cards? And again, we're going to address ID in much more detail in September, but while we have you here, I would value your opinion. What would the basis be if the standard is probable cause, exigent circumstances? What would the basis be for making folks submit to what would necessarily be a Fourth Amendment search for purposes of a ID, whether it's a fingerprint or something?
The case that I handed up from U.S. Supreme Court 2004 is a Hybel case.
Yeah.
Addresses that pretty well. In that case, they upheld a Terry type of stop in which they asked there was a statute that said that you had to identify yourself if the request was sufficiently related to the reason for the stop. And the Supreme Court said if it is sufficiently related to the stop, if you want to know someone's name and you have a reason to stop someone under the old Terry standard, articulable suspicion, then you would have to give the name. Now, you get back into I keep blaming California, and I think I'm right about that, but there's a case, the one where they said that you had to give credible evidence of who you are, and I guess that's an identity card. I don't know. It would seem to me that to require people to carry an identity card walking on the beach would be a bit absurd, but to carry a passport on an airplane going to France, I think it's a reasonable requirement. So it's a moving target, I guess is what I'm saying to you. There are circumstances where you can be required to carry a passport. You can be required to have a driver's license when you're driving an automobile. Because and there is an offense, a traffic offense for no license on person. I've got a valid driver's license. I left it at home, and they can cite me for not having it on my person, which unfortunately happens. I haven't been stopped for that, but when I take my kids to school in the morning, I'm usually in my pajama pants and don't have my wallet with me. But those.
School?
Yeah.
Better watch the sex predator.
Yes, I got you. That's good.
Let me give you a case that you might, a scenario. A homeless person is walking down the street of Atlanta, has no ID. Stopped by an Atlanta police officer. Officer says, "Show me your ID." "I don't have any." "I'm going to take you to jail until we can prove who you are."
Well, I don't think under Georgia, I don't think there's any statute in Georgia, maybe, but I'm not aware of any statute in Georgia that would require that. Now, they might try to stretch obstruction of an officer to that degree, but I don't think it was
You just look suspicious. We got to hold you until we find out who you are. You don't have any ID on you.
Well, this
is real.
Well,
it happens.
Well, and that's why we don't trust government. That's why that's why we have these wonderful standards, and we have great district attorneys, and we have the GBI, but not everybody lives by those standards, and that's what we have to recognize, is that we're entrusting our security to people, to the government, and officers are as good and bad as lawyers are. They come in all shapes, sizes, and moral standards. What you've just described to me is an illegal detention. Now, if you had the statute that Nevada has, in which you have to give your name, which and the Supreme Court said that's not unreasonable. The officer has a reason to stop you, and that's the first question: does he have a reason to stop you, and ask you who are you, and you refuse to give up that information? Then that's a violation of that Nevada statute, which has been upheld by the Supreme Court. On the other hand, if he's just kicking poor folks around and has no reason to stop you and just ask you who you are, and you say, go eat worms, I'm not going to tell you who I am, that's constitutionally impermissible. That you cannot stop them for no reason. You have to have that articulable suspicion. If Georgia has an identification statute, other than carrying a driver's license when you're driving, and that type, sort of case-specific type of thing, I'm not aware of it. It may have, and I, based on the Supreme Court precedent, it would not be constitutionally infirm. It would be acceptable to have such a statute, the Nevada statute, not the California statute. I would have a hard time believing that it would be constitutionally permissible to arrest someone for not having just an ID. And that's going to get into all these immigration questions and the illegal aliens and questions that, gosh, we never thought would be questions, but they're here, and the answers, unfortunately, are not crystal clear. Some of them seem clear, and we certainly have opinions about them, but some of them are not clear questions. I'm glad it's your job and not mine. See, I can argue with what you guys do, but you have to accept what you do. If there are no other questions,
Mr. Donaldson, I appreciate your time so much.
Thank you very much.
All day today. About 1:30, puts us about an hour ahead on our schedule, which I don't think anyone's objecting to.
No.
Is GBI prepared to talk? Do you want to take a 10-minute break and then?
Let's
take let's take a 10-minute break and we'll get started at 1:45. Been with us all day. Before we get started with GBI, Mr. Keenan, we've got the message down from committee services that we're not faithfully turning our microphones on when we talk. We're talking into our microphones. So my able assistant's getting beaten up by her staff that we're not doing our piece. So let's just try to redouble our efforts to keep talking the mic so this can be recorded for record. And Ms. Nuremberg, who's taking good care of us, can be taken good care of. That being said, it's a little after 1:45. Again, we're a little ahead of our schedule, which is a good thing. I think we've addressed things in considerable detail. I'd like to thank all the folks who've traveled to be here and taken time out of their very busy days to be here and share with us. That being said, I'd like to turn it over to Mr. Vernon Keenan with GBI, and GBI has a tremendous amount to offer us today in their piece. So, Mr. Keenan.
Thank you, Mr. Chairman. I'd like to say sincerely that I and the rest of the GBI staff appreciate the opportunity to come and speak and make presentations to you. Many times there'll be subjects that are discussed that the GBI has expertise in, but will never be asked what the facts of the matter are. And many times there's a lot of speaking that goes on in subject matters that is done through the emotional side, whereas GBI is here to speak to the facts of how the programs operate that you've been discussing previously.
Mr. King, I think the only thing more dangerous than the blind leading the blind is the blind leading the informed, the well-informed. And sometimes we as a legislature will do that. We're trying not to do that to you. So.
Yes, sir. Well, thank you for saying that. I've noticed that before in my position as GBI director. I have been in law enforcement for 35 years. I've been with the GBI since 1973. So I've seen many changes in the criminal justice field. I recall that when I started in law enforcement, that the Georgia had the Department of Offender Rehabilitation. At that time, it was not even referred to as prisons. It was facilities that were to rehabilitate people. So we came from that perspective all the way over to very strong 3 strikes, 2 strikes and you're out now. So I've seen many changes. I know that Representative Tyrone Brooks introduced legislation, I believe it was in 1984, which was the Anti-Terrorism Act.
Actually, in 83 we introduced it. We passed it in 84.
And that legislation has been extremely important to the history of this state, because those laws were used by the GBI to break the back of the Ku Klux Klan in this state. And so there are many important tools that the General Assembly gives to law enforcement. That's why it's extremely important that the legislature have committees like this that look in depth into how law enforcement operates and what the needs are, because we can actually operate from 2 extremes. We can have an extreme that puts privacy above public safety, and you can have public safety above privacy. The fact of the matter is there is a balance test there, and the proper balance of privacy and public safety rests with having debate and public discussion, and that's why we're here today. The 2 areas you've been talking about, fingerprints and DNA, both of the databases that the state of Georgia operates rest in the Georgia Bureau of Investigation. They're in two of our divisions. Just to refresh the members of the committee here, the GBI is the state-level investigative agency for Georgia. We have 3 separate divisions, one of which is the investigative division. That is where the special agents and the drug agents do their work. The other 2 divisions are sole source providers of service to the entire criminal justice system in Georgia. That's the State Crime Laboratory and the Georgia Crime Information Center. State Crime Laboratory is the only crime laboratory in Georgia, and we provide forensic services to every prosecutor, every court, every law enforcement agency. They work nearly 90,000 cases a year on behalf of local law enforcement and prosecutors. 3rd Division, Georgia Crime Information Center, is the computerized criminal history record system for Georgia, and they have over 2.7 million offender records there. And that's the first issue first presentation that I would like to make, Mr. Chairman, and this relates to the fingerprint section in the Georgia Crime Information Center. And I think that as we go through this presentation, it will answer many of the questions that have been presented by the committee members. And as we get into this presentation, to preface that presentation, I'd like to say this. There is very much a tendency in criminal justice and law enforcement to try to move to adopt programs based on new technology and forget what the basics are. The basic system to identify people in the United States, identify persons in the United States, is fingerprints. Now, there's very much a tendency to say, now we can do better than fingerprints. We can get into DNA. We can get into facial recognition. We can get into many other biometric systems there. The fact of the matter is, the recognized standard for accuracy and ease is fingerprints. So we're very guarded in the GBI about just because there's new technology out there of jumping out and saying we want to go forward with this, when in fact we've got a recognized set of standards and a recognized system that is workable and has accuracy. So with that, I'd like to have the first presentation made by our Assistant Deputy Director from GCIC, Ms. Terry Gibbons. Terry has gone with me to many presentations because she is in fact the subject matter expert on the fingerprints.
As the committee probably recognizes, the recognition that people's fingerprints are individual and the use of those for positive identification had existed well in as early as the 1800s. First practical application for law enforcement though came in 1903 when fingerprints were used to distinguish between two prisoners who had similar name and similar characteristics. Since the early 1900s, that has grown from identifying prisoners to being able to use positive identification for other criminal justice purposes. The FBI established their identification division in 1924, and as the director mentioned, in 1973, the GCIC was established as an operating division of the GBI for the purpose of being the chief provider of criminal justice information for state criminal justice agencies. And that included developing a statewide criminal history repository and a fingerprint repository for criminal offenders. We talked about technology, and I want to go and throw that out there now because obviously that is such a big part, has been such a big part for the last few decades. Georgia did purchase an automated fingerprint identification system, or AFIS, in the late 1980s. 1989. And basically what it does is automate our fingerprint repository functions. An AFIS, as most of you know, is a computer system that's designed to store, analyze, retrieve, and match fingerprints against those fingerprints that have already been collected and are maintained in the database. Our matching accuracy with the AFIS is 98% or better. Usually really it's more like 99%. It's much, obviously the computer has the ability with that specialized software and matching algorithms to be much more accurate because it's looking at specific features and extracts from those images. One unique feature for the Georgia AFIS was we were the first in the world at the time to have what is considered an integrated process between our fingerprint identification and our criminal history update. And basically that means that once we make the fingerprint identification from the arrest card that's submitted, the criminal history record is automatically and immediately updated based on that arrest submission. The two fingerprint databases that the GCIC is primarily responsible for, the GBI, is the 10-print database, and that consists of all the rolled or 10-print images from post-arrest submissions. When an individual is arrested and booked, those images are sent to GCIC for processing, either to establish a criminal history record or to update the offender's criminal history record. And then the second one is the unsolved latent database. Those are latent prints that have been lifted at crime scenes that, there's not a suspect, they are not able to identify a suspect. We have processed those against the 10-print database and still there's no individual identified. So we store those as unsolved. And we'll come back to those in just a little bit. The 10-print database first basically serves two purposes, as I mentioned. The first is positive identification, print to print, to make sure for either criminal justice purposes or non-criminal justice purposes. For criminal justice, obviously when an arrest submission comes in, we can link that arrest to the offender's record correctly, regardless of what information they give in terms of name, sex, race, or date of birth. We're making that comparison and match based on fingerprint submissions only. And our statistics show that 68% of offenders have previously been arrested in Georgia. So. Then the second one is to use that 10-print database so that you can search unsolved latent prints against the known offender file.
Excuse me, ma'am. The non-criminal justice purposes, what exactly are those, just so we'll know?
We'll go into that a little bit more later, but basically that would be for licensing or employment. If an individual gives consent to their employer to run their criminal history record, and they do it based on fingerprint submissions, it goes against the offender file. The director mentioned our 10-print database contains images for over 2.8 million offenders in Georgia. We receive and process 500,000 arrest submissions annually. Georgia usually ranks around 4th or 5th in the U.S. in terms of submissions of post-arrest cards. The fingerprint submissions are required statutorily for any felony arrest and for any misdemeanor arrest that the Attorney General has designated as a fingerprintable offense.
Could you enumerate what those might be?
There's a laundry list. There are very few traffic offenses, except for like maybe DUI or driving with suspended license, but it might include misdemeanor theft, misdemeanor shoplifting, misdemeanor assault.
Obstruction of a police officer, simple battery, simple assault.
Misdemeanor possession of marijuana.
Okay. Parking tickets. You're safe.
We don't keep parking tickets. They're good. Once we accept the fingerprint submissions from the arrest submission and we process it here at the state level and update our criminal history, we then forward the information electronically to the FBI. They process it through their automated fingerprint identification system and update the national criminal history. In addition to the standard processing that we do for identifying arrest submissions and adding them to the criminal history, is criminal justice agencies can ask for special 10-print identification services. They can also ask for certified copies of prints if they need those to develop their cases or prosecute their cases. We do have about 23 local agencies that have what we call APHIS remote terminals. And from their location, before they book an individual, if they're not sure or they don't feel like they've given them correct identification information, before they book and arrest them, they can submit that 10-print for a search to determine who really is this person that I'm dealing with. We mentioned about the civil submissions. We do provide criminal history background check services for non-criminal justice purposes such as licensing, employment, adoptions. We receive and process a little over 155,000 fingerprint requests annually for that purpose. Once we process it at the state level, we return the criminal history record back to the employer. The individual has given consent with their fingerprints that they want that information to go back to their prospective employer or the licensing agency. If it's authorized by state or federal law, we then submit those prints electronically to the FBI, and they will do a national search and return those results to the employer as well. Neither at the state level or at the FBI do we retain any applicant data or fingerprint images. Once we've processed it and determined they don't have a record, or they have a record and here is the criminal history record, we're done with that image. The second database is the unsolved latent database we mentioned earlier. Those are images, features of prints that have been lifted at the crime scene where there's not a suspect or it's been searched against the known offender file and no potential suspect was identified, so we store those. Fingerprint examiners can go back periodically, both at the GBI and local print examiners. They can search those against new arrests that might have come in. And the APHIS, one of the features of the APHIS is that it would automatically search that file as well. Every day as we're processing those new arrest submissions and those new civil submissions, it will go and check against that database to see if potentially we now have a match. Now, and that has occurred. It's usually less than 1% chance, but there have been instances where an unsolved latent print was identified against a new submission.
Mr. Chairman, let me give you an example here. The very first case that we saw with the APHIS involved the rape and murder of the aunt of Governor Joe Frontier. And she was assaulted, raped, and murdered at her home in Cartersville. And we recovered a latent fingerprint from her driver's license where the perpetrator had gone in and rifled her pocketbook. Left his print on her driver's license. We ran that, did not know the name of the perpetrator, had no suspects in the case, ran that fingerprint against the GCIC database and found that it matched a young man who had been arrested in Monroe County, Georgia on a drug charge, and they had taken his fingerprints and submitted to the GBI. That was the very first APHIS match in the state. So that's also an example is still valid of how the system works. It's done through technology and accuracy.
That's correct. And another example we had is we had an individual who was applying to be a corrections officer with Department of Correction. And when we processed those applicant submissions in there for corrections, at the individual's consent, those prints matched against a unsolved latent print that had been stored from a crime scene as well. So so he ended up on the other side of the ball. The current database size for the unsolved latent is a little over 5,400. Keep going backwards on that. The latent print search and identifications that the APHIS provides, can lead to potential suspects or provide investigative leads as for those crime scenes where they do not have a suspect that they can compare prints to. And as the director mentioned, that's part of one of the features of this technology is that you can do that because a computer can obviously do those searches much faster and quicker than a human person can do that, and it's much more accurate because you're looking at certain features to match on. In the last fiscal year, over 9,800 latent print searches were done. There were 982 matches made, so a 10% hit rate.
Individual confirms with the computer tells them about the scientist makes that confirmation.
That's correct. Right. Once it produces a potential list of suspects, then the examiner would go through and verify that. And this is not very good in terms of the color, but on the latent hits that were made in the last 12 months, majority of them are the other category. But generally, your property crimes, your burglary, robbery, theft crimes, they find a lot of matches on those. I think there were 14 homicide cases. So again, the benefits of APHIS, obviously the identification drops from days to minutes. 90% of the arrest submissions that are sent to GCIC are sent electronically through live scan technology. And that basically is an electronic capture of the fingerprints. They submit that electronically to GCIC within 30 minutes approximately from the time the arrest and booking is made. The individual has been identified, that response returned to the arresting agency, and the person's criminal history updated at that point. And of course, the accurate and timely update of criminal history records, and I know the committee was speaking of that earlier, is important for criminal justice purposes, for public safety. Criminal justice agencies use this in the administration of their duties in terms of investigations, prosecution, sentencing, and so forth. But it's also, so it provides immediate identification information to the local agency so they know whom they're dealing with. But it's also critical for non-criminal justice purposes such as employment checks or licensing. And one example might be an individual who's arrested and booked for domestic violence. He leaves the booking station. He might head straight to a firearms dealer. By the time he fills out his form and the Brady check is done, that record has already been updated, so that can at least delay, hopefully, the potential purchase of that weapon, if not deny it, and therefore hopefully preventing any further violence. And then, of course, as we mentioned, the ability to search and match numerous prints will help in terms of unsolved latent print. In terms of security, the Georgia APHIS and the databases that are within APHIS are maintained on-site at GPI in a secure environment. There's access controls. Images and data that comes to us electronically must come over dedicated lines, so it is secure in terms of sharing of that information.
When you talk about dedicated lines, is this exposed to the outside at all, or is this a completely offline database? I mean, data that's transmitted to you through some line, some outside line, is that then taken by some media and put over into the database?
No,
or is
sir.
it?
It's directly from the individual agency to the Georgia APHIS.
Okay, but these are dedicated lines that don't run along on the normal phone architecture, or?
I think so. I'm
It's not like the internet. I mean, dedicated just to getting the evidence from the local agency to GBI, so it doesn't go out to the world to hack into.
I might can answer some of that since I'm in the technology field and we actually work with some municipalities. If it's using the same type of circuit that the GCIC links do, those are dedicated point-to-point circuits that go from GBI to the local law enforcement agency. So I'd assume it's either using that same point-to-point circuit. So it would be secured and it would be within the closed USA GBI network. So,
thank you.
even though technically every line crosses a public network, but it's a secure method of doing that.
Again, the benefits of the use of the fingerprints as biometric data for criminal history records is we do make sure that when we apply that arrest to the individual's record, it's being done based on positive identification. Again, regardless of what name they may have used at the time they were arrested, we can make that identification. It is valuable for background checks. If an individual, we probably have about 100 to 150 individuals a month that come to GCIC say, my employer denied me a job because they said I had a record and I did not. We'll come to find out usually that was because the employer ran a name search, or they may have gone to a private consumer reporting agency and gotten information. And yes, the individual's name and descriptive data may have been used by someone else, either a family member or identity theft. With the fingerprint comparison, we can give them a certificate that says either you don't have a record, your name has been used, or they do have a record, but not this particular arrest is yours. So, and that just ensures that individuals who do not have disqualifying criminal history records are not excluded unfairly from employment. And likewise, those who would lie about their identity might not necessarily, they can't really hide. They won't be placed in positions where they can do economic or personal harm if you use the fingerprint-based check. Just a reiteration again that fingerprint-supported criminal history records do ensure that the record is correct, is positively identified to the individual, and that the ability to search those prints against those known offender images will lead to potential suspects. Biometric data, as collected and used by the GBI, certainly serves criminal justice agencies as well as non-criminal justice agencies such as licensing agencies or employers, and it can benefit the individual, ensuring that, again, especially in whether it's an arrest issue or an employment issue, that they're positively identified or qualified.
Yeah, I've got one, just more technical question of interest is you had mentioned 98% accuracy. What would cause the 2%? I mean,
majority of that would be from poor quality prints, usually from original prints that were stored, perhaps that were collected in the 70s, 80s, 90s. They may not have been good quality. Okay.
So it's nothing to do with the person's fingerprint being so close to someone else's?
No, so usually it's either the quality of the print on file or the quality of the print of the individual who's being arrested at the time.
Okay. Just something that sparked my interest there.
Every match requires a scientist to pull the documents.
I knew it was pretty accurate science, and that's why I was like, I thought it was more accurate than that. So,
and usually it does run about 99%. The contractual requirement is for the vendor to provide 98%.
Okay. So I can't burn the fingerprints off, is that?
All that long time.
Yeah.
That would rise way more suspicion.
Yeah.
Well, unless you did all 10 fingers, you might be okay there.
Any question over fingerprint? Pretty good rundown. I can make a couple observations here. One of the, as Terry was saying, 90% of the fingerprints from arrested persons are submitted to us electronically. Currently, fingerprints that are sent to us for the licensing checks, the civil background checks, are sent in by fingerprint cards. That has created a backlog in the agency because those, when actually ink cards are sent in, that takes a minimum of 20 days to process. That has an impact on adoptions. When someone that goes to adopt a child, they have to go through a fingerprint-based checks. Licensing for school teachers, private detectives, real estate, banking, all of this. In the spring of 2007, we're going to a format at GCIC where we will begin to receive all of the non-civil, all the civil prints electronically. So we'll be doing those database turnarounds within the 30-minute time frame that Kerry Gibbs is talking about. It's going to solve a backlog in the licensing process in the state, and that's something that we've been able to do that through Homeland Security funds. Because what is happening now in today's law enforcement Homeland Security environment, identification by fingerprints is extremely important. Trying to identify someone through a name check there's all types of problems associated with that. And that's why cringe when I hear proposals to do facial recognition taking place of people proposing that taking place of fingerprints or DNA identification taking place of fingerprints. I do not believe it will happen. That's to me, that's a lot of vendor talk out there. People trying to sell products. When the fact of the matter is, you see from this state has an excellent track record. Now, one of the things that is very important in town, that Terry's here can address some of the issues related to expungement of records because that is handled in her section. My view on this, and it is a fact of matter, that when someone is arrested, they have crossed over a bridge in their life that is, there's no unringing of the bell. As Pete and I were talking a few minutes ago, you can't unring the bell. We may could expunge the fingerprint records by the process outlined in the law, but you can't undo. You can't. The record that was created at the police department still exists. The court record exists if it went that far. There may be a newspaper account of what's happened because they get a copy of the police blotter. So it's not just a simple matter of saying we can expunge the fingerprint record and it all goes away. It's not that simple. The key to this, in my view as GBI director, is accuracy of records. That if someone has been arrested and that case has been dismissed, then there ought to be an accurate record that so spells that out. If a person has gone to trial and has been acquitted by jury, the disposition should be on that record if it's not expunged. So there's an accurate reflection of what the disposition was. And this is a battle that the GBI constantly fights with local jurisdictions because our records are based on what they submit to us. If they fail to submit a final disposition, then we have what's called an open-ended arrest that creates the problem that Mr. Brooks is talking about, impact on someone's life, and in fact, their case has been adjudicated in their favor, but the record exists saying that merely they were arrested, and that creates all that problems. So if I could get Terry to take a few minutes to explain the process of how that is handled in the GBI, because that is our responsibility.
Certainly. And as the director mentioned, that getting accurate and complete records would be the best in the world. Georgia is not perfect. We're probably one of the better states. 80% of the arrests in the last 10 years do have disposition information. And with our new criminal history replacement to be implemented next June, we're going to add a prosecutor segment, which we're hoping will allow us to pick up some more interim-type dispositions. But an expungement, it's allowed under Georgia statute either through a Superior Court order if the information is inaccurate, incomplete, or misleading. And a court order requires us to remove everything in its entirety, the arrest information, the fingerprint information. For those individuals where the arrest was dismissed either prior to indictment or after indictment or accusation, if certain criteria are met, can petition the local agency and the prosecutor to have their record expunged. If that's approved and sent to GCIC, we seal the record so that it's still available for law enforcement, but it is not available for employment or licensing agencies. And we do get a number of those. We probably get about 3,500 requests a year for those types of expungements. So it is a pretty prevalent option for that people avail themselves to.
Is that a pretty manpower-intensive thing to do for you? From a workflow standpoint, does it take a lot of time to make that happen and check it and make sure, or is it a pretty simple thing?
It's a pretty simple thing in terms of the actual actions that are required to seal that record. But when you add that with all the volume of that workload plus with the other workload, it does become labor-intensive sometimes. But the actual action of going in and saying, adding a flag that seals that record is pretty simple. And we are able to, we had an individual prosecuting attorney today asked to rush one. So once we get it, we can pretty much process it within a couple hours.
And I simply asked that question not in the context of what this committee is contemplating, but, we were talking before about looking at expungement as a state. And if a much more aggressive stance were taken that expungement were to happen much more frequently than when one could appeal to the district attorney and get it executed, it could be happening much more frequently.
Well, I would like to qualify my statements. That concerns GCIC's actions. I mean, the prosecutor still is required, and the local agency still is required to review that and make a recommendation. So
sure.
Depending on their workload and what they have to do.
Your point here is very important, Mr. Chairman, that if there is any change in legislation which increases the workload, that we always welcome asking
corresponding funding
and impact on the agency because some things may not be workable with existing resources. we're more than happy to lay out the cost. Any other questions over fingerprint? Next presentation we'd like to do is over DNA.
Mr. Director, if I could ask, do you maintain the DNA database as well, or who maintains the database?
The DNA database rests with the GBI crime laboratory.
You're a step ahead of me, Mr. Director.
If I could take just a moment to give you the history of DNA in this state. When the GBI first established its DNA unit, it was in the late 1980s. And I recall that this is when DNA was first becoming recognized as an important law enforcement prosecution tool. Our single DNA scientist would go to court around the state, and he would have to convince the court, have to convince the judge and the jury that DNA was, in fact, had a scientific basis, and it was not some voodoo science that was new on the spot. We went from that in around 1986, that time period, to today, where it is almost a district attorney and law enforcement are questioned very, very hard by juries about why we don't have DNA evidence. We go from convince us it's valuable to, if you don't have it, then there must be a problem with the case. We started, the first DNA laws that were passed required that there be a DNA sample taken from persons that were convicted of certain sex crimes. And those DNA samples were taken at the time they were incarcerated, and they went into the GBI's database. The next piece of legislation required that every felon who was convicted and incarcerated, that their DNA sample be taken at the time they were in the system and submitted to the GBI. The law was later amended to say that the DNA sample would be taken at the time they entered into the Georgia prison system. When those laws took effect, that is when we really began to see the impact and the value to law enforcement. The chart here will show that in just a minute. I heard the discussion this morning talking about taking DNA samples from persons that are arrested. As you saw from the number of fingerprint cards that the GBI receives each year, that's around 500,000 persons arrested in the state of Georgia. I think it would be extremely, extremely expensive if the state decided if the laws were enacted requiring that persons who are arrested give up a DNA sample. It's going to be extremely expensive. My view is that the next logical step in handling DNA evidence from and handling DNA samples taken from offenders would be to go to a system that a law which would require everyone who is convicted of a felony in the state of Georgia give up a DNA sample to go to the system. Currently, on an average, there are 42,000 felons in the state of Georgia that receive probation in lieu of incarceration. Those 42,000 each year do not give up a DNA sample, only if they are actually incarcerated. My view is that it would be extremely important in the next logical step if we expand the DNA requirements to go into all convicted felons, and not even. That would be a step that the state should take before they ever consider doing anything with a misdemeanor conviction or any other type of arrest. With that, Mr. Chairman, I'd like to call on Dan Kirk, who is the Director of the State Crime Laboratory Division of the GBI, to make some remarks before we introduce the actual subject matter of the program.
Thank you, Director. Just from the crime lab standpoint, we want to thank y'all for having us down here. It's again, it's not too often we get to come down and tell people how it really gets done and why it gets done. And what we've done is put together a presentation that will hopefully educate you with the terms of DNA, what's DNA about, how do we do it, why do we do it, how do we maintain our database, what goes in, what statutes, both federal and state, allow us to do that. and then talk a little bit about the security, which something that hasn't, I don't think, been talked about here a whole lot regarding databases, but I think is something that your committee is going to have to take a look at. Is not just the fact that what can we do biometrically, what can we take, but then how do we secure that, and how do we keep that safe from other means of identity theft, as we've seen our credit cards and so forth get stolen from us. But anyway, so that's what this presentation is going to focus on. I just want to piggyback on a little bit what the director said about in terms of where are we going in the future with our CODIS database. And I've heard a lot here today about arrestees, and I almost get the feeling that there's some rumor out there that the crime lab is advocating, or the GBI is advocating, that we go to all arrestees. And let me say that that's not where we are. Certainly federally, the federal system now requires all arrestees to be sampled, but that's not where we are. What we are looking at is the effectiveness of what our system has been able to do with convicted and incarcerated felons, and with where we're seeing the types of crimes that we're seeing come up, and what these people are arrested for, and then what they're actually other crimes that they committed. We're saying that, hey, there's 42,000 people out there that are felons that aren't being sampled, and we know that there are crimes that those people have committed that are probably can be solved if they're in the CODIS database. So that is the next step, I think, as far as our state should go in terms of where do we go from here. Let's take it stepwise. Let's don't jump to arrestees, but let's look at those convicted felons and see what it can do for us and see how we can maintain that. So with that, I'm going to have the subject matter expert come up and talk to you about DNA. Ted Staples is a manager of our forensic biology section. He's been with the crime lab for about 20 years. He's seen forensic biology go from the old blood typing all the way through RFLP, the beginnings of DNA, all the way up to what we're doing today. So he's seen the entire change. We've also been a part of the national effort on CODIS. There's an INDEX board, which is a National DNA Indexing System board, which governs produces the policies and procedures that all states throughout the nation must follow in order to participate in the CODIS database program. And Ted was actually part of that board for 2 years, and so Georgia was well represented during the birth of these policies and procedures. So with that, I'm going to turn it over to Ted, and he's going to tell you all you ever wanted to know about DNA.
While you're still here, can I ask you, and either you, Ted, or the director, if you'd like to answer, just to quantify it for me? You said there's 42,000 felony convictions per year where the folks are not then incarcerated, that we're not collecting samples from. What's the number of incarcerations we are collecting samples against, just for the incarceration piece? Do you know?
We run about 1,200 to 1,500 a month.
Okay.
About 18,000 a year.
Okay.
And for some reason last year we ended up about 22,100 is what we ended up doing.
Now, another question I've got for you. You referred to the federal system, all arrestees are sampled. Is that felony arrests or all federal arrests of any kind?
The act that was signed this year simply would allow a state, if they had a law, it would allow a state to then collect and upload DNA from those individuals. Arrestees, indicted individuals, or obtained under appropriate legal authority.
So it really gives states very broad authority to decide in the state what they want to do.
Oh, exactly. And that's always been the stance of the FBI, is they're not going to tell the state what to do, but they have to set the ground rules for what you can do.
But, for example, on a federal installation, if you were arrested by marshals or whoever were to arrest you, felony, misdemeanor, would they, on a misdemeanor theft, and I don't know federal law at all, but would they collect a DNA sample for a misdemeanor case? Or?
It's my understanding now, if you're arrested, you're being sampled under federal law.
Wow. And I ask that question because, again, part of one of the things that's interesting about state politics is it's a study in comparative politics. You benchmark yourself against 49 other states. You benchmark yourself against a federal standard. In many cases, when there's uncertainty, we'll kind of fall back. I mean, in this very committee room, we said, well, what's the federal standard? And you use that as a benchmark. You look at the states. We've got 6 states that have taken a more aggressive approach. Then you've got the feds, which appear to be out there. That's part of the inspiration of the committee, is that we understand where things are, where things may be heading as a country, that we put ourselves on the spectrum where Georgians want to be. But I appreciate that. That's something I wasn't aware of.
Mr. Chairman, we're going to put that in perspective. Our cost analysis to do the 42,000 felony probationers each year would be $1.5 million. That would be a recurring cost to the GBI. Outsourcing, if we outsource that work, it'd be $1.6 million. So if that's the 42,000, if it's 500,000 arrests made each year in the state, someone can do the math and give an idea of how much it would cost each year. And quite frankly, we would not have the capacity to do that volume of work. Federal government is going to be stumbling on how they're going to, I view as ever stumbling on how they will handle that volume of work.
Understand. Thank you.
All right. Well, it's a pleasure to be here. I was one of those that Mr. Keenan was talking about, going around the state trying to convince judges that DNA was real and not voodoo. So, been there. Some of the things that I want to run through today, as Deputy Director Kirk mentioned, was just the DNA database. What is it, and how does it work? The hierarchy. A real brief how we handle evidence, which goes to security and tracking of that evidence. What we do in my section as far as testing, how do you even get a DNA profile? What is that? The offender DNA testing, and then just real quickly touch on, I'm not an attorney, but federal and state statutes, because that's what we live by. And finally, just a real quick summary on our DNA database program here in Georgia. And there's some pretty surprising information in there since our law expansion. So first, CODIS essentially is the DNA database, and that stands for Combined DNA Index System. It is an FBI-based system. That software was developed privately through the FBI, commercially, and it essentially allows for an electronic comparison of DNA profiles. That's what it does. To solve cases, link cases, or even identify unidentified human remains. The 2 types of hits, the terminology that we throw around are forensic hits, in which we link cases to each other. And the second would be offender hits, where we link offenders to unsolved cases. And I'll talk a little bit more about this later. And GBI began participation in this program in 1998. We were the first non-test state allowed into the system in 1998. There are currently 50 states using CODIS. That includes 177 state and local labs. There are 3 federal labs. That would be the FBI, the Army Crime Lab, and they consider Puerto Rico another federal lab. All of this, again, it is governed by federal state law. The federal law sets the parameters to operate by, and then it's up to the states to decide what you're going to do. At the national level now, there are over 3 million profiles, and 26 countries now also have CODIS in 41 different laboratories. The hierarchy of the way this works essentially is a local lab, and these are law enforcement labs, not private labs. Law enforcement labs would perform the testing, upload the DNA information to the state lab. The state lab would then search to determine if any cases are solved or linked, and then the state lab then uploads to the national system. And the terminology they use are National DNA Index System, State DNA Index System, and the local DNA Index System. So for Georgia, our regional lab in Savannah, the coastal laboratory, would be considered a local lab. They run DNA, enter their profiles that are appropriate to go into CODIS, upload them to us at Decatur, we search, and then we upload to the FBI weekly, and they search over the weekend. That's the hierarchy of how this works. The relay of information, the CODIS terminals are all installed by the FBI. Once you are approved to participate in the system and you sign a memorandum of understanding, the FBI then takes it from there and sets up these terminals. All the lines, as was mentioned earlier, are dedicated lines to the CJIS WAN. This is the Criminal Justice Information Services Wide Area Network, and all these are dedicated lines. So it goes from GBI to this secure installation in Clarksburg, West Virginia. That's where it goes. They are not networked internally, therefore nobody else within the GBI can go in and look at anything. We have chosen not to do that. Also, and a lot of people don't know this, is that each user, once you're DNA trained and you pass training and you become a DNA analyst, you then have to undergo a separate background check by FBI to become a CODIS user. So you could have been working at GBI for 5 years and we're ready to make you a CODIS analyst. You then have to undergo another background and fingerprint check by the FBI before you can even get a logon name. So there's a lot of security here with the data and the information. For example, Deputy Director Dan Kirk, he can't even get on and log on the system. He can, of course, come up and tell me to, but he can't log on the system.
Yeah.
Moving into real quick, of course, I think everybody knows the evidence are submitted by the law enforcement agencies to the lab. It's entered into our laboratory information management system. All this is electronic. It receives a unique number, and each item of evidence receives a unique item number within that case number. And then the evidence receives a barcode, and it's tracked everywhere it goes, from the time it gets in, the date, the time, who it went to, where it was stored, up until and if it's returned to the agency. It is tracked the entire time. For my section, we are essentially twofold in what we do. Our first role is casework, the normal testing you would think of. Is it blood? Is it semen? Is it saliva? Does this knife, is that reddish-brown stain, is it blood? And, of course, we perform DNA on that. Our second role is the database, where we're performing DNA testing on all incarcerated felons. And, of course, that's to search the database to hopefully solve unsolved cases. And all of those samples from the offenders are retained at GBI in the vault indefinitely. Just real quick, a cartoon kind of what we do, the DNA process. Say you have a swab. We cut a portion of that swab, put it in a tube, and we remove the DNA. If it's a sexual assault case, we then split that into male and female components. We then carry out further to clean up the DNA on these robots. We then carry it through what's terminology is PCR, where we copy the DNA we want to look at, run it through a genetic analyzer, and this is what would come out would be a DNA profile. This is one area or one of 13 areas that we would look at. But essentially, these numbers become that person's DNA profile. We then take that information, so the top frame would be, let's say, from a suspect, either buccal swabs now that are collected from the mouth, a blood sample, and then the bottom would be the evidence, and then those are compared and determine not whether you have a match.
What's the total possible number of combinations in a profile?
He asked me that yesterday. It would be essentially in the billions or trillions, because of course all of this information for that individual would be based on their genetic, what they got from their parents. So depending on the area that we're looking at, say there are typically 14 different combinations that you could have. Plus you have 2 sets of chromosomal markers, so now that's times 2 out of those, and we're looking at 13 different areas. So real quick, the math shoots it up again into the billions or trillions as to the combinations. So that's essentially, we get the profile, we see whether it matches or it doesn't match. So now we got this profile from the evidence, what do we do with it? And again, the areas that we're looking at for forensic DNA, and these areas are essentially worldwide that are looked at for these 13 different areas. They have no known function. Therefore, if they have no known function, then they cannot be linked to any disease or propensity to disease. They're simply there in a person's DNA.
In other words, the insurance company would do them no good to reach into CODIS and grab genetic information to determine whether or not you have a propensity for a certain disease to decide whether or not they're going to give you insurance coverage. That is the importance of that. Plus the fact that it's not going to be changed or altered by disease.
Something Director Keenan touched on just briefly, 1994, the Georgia Law 24460 outlined that we could sample sex offenders. 2000, that was expanded to all incarcerated felons. Our CODIS database at that time had grown to about 5,500. That was both casework samples, probative forensic samples, and the sex offenders. 2001, we received some basically robotic high-throughput equipment, some additional money that was desperately needed, and CODIS shot up to about 28,000 profiles. 2002, we reduced the backlog, but in 2004, the law was changed somewhat that would allow us to also collect from those sentenced to life or death row. Previously, we had not been getting those individuals. And then now we have over 100,000 profiles in the system. Real quickly, how the offenders are tested. The samples come in from the prisons. They're in an envelope. It's an envelope with 4 swabs taken from the mouth. There's also a form by the prison, the name, their prison ID number. There is a thumbprint on there, and whatever crime they were incarcerated for. Our evidence receiving technicians will open those. They verify the envelope is sealed, as the state law says. They compare the name on the envelope to the name on the form. And we enter these 90 at a time. That's simply because that's the most efficient way to run on our equipment, is 90 at a time, and each has their own separate item number. Once it's entered, a barcode is generated, goes on the swabs. The person enter it will then scan it to a temporary holding area, and the forms are scanned in electronically, so we have all that data essentially on demand. After this person is done with it, our laboratory tech will come get it. She will then load the samples onto these robots. Again, they run 90 at a time, and we type them, develop the profile, and they go into CODIS. Just some of the statutes to touch on. The federal statute, the DNA Identification Act, is Title 42, specifically addresses disclosure of this information, as well as the Federal Privacy Act notice on the National DNA Index System, and this was amended in 1996. Of course, the state statute we've already touched on today, 24460 all the way through 65, touches on these areas.
Could you hold right there? I'd like to get that.
Oh, I'm sorry.
FCGA records. 24460 through 65. Super. Thank you.
That federal law that was I just had up there, that legislation that was passed that addressed disclosure, that's then transcended into the operational procedures. This is the board I was on a few years ago. These operational procedures are then based on that federal law that states that participate in this have to abide by. And just real quickly, this Section 4 deals specifically with disclosure of those stored DNA samples. And those are criminal justice agencies, judicial proceedings, criminal defense purposes. That defendant has a right to it in the case they're charged, and if so choose, use it for a statistics database. And all of those, you're basically saying that by signing that MOU that you agree to participate in this under these rules and regulations.
Are there dollars tied to that? That if as a state we decide, they're changing this thing, we don't really want to comply anymore, do we get penalized $20 million or something?
Well, big time. We get audited, and then if you don't comply, you lose all your federal grants.
Federal grants for what?
Whatever you got.
Any federal grant. For example, let's say we've got a DNA federal grant, or there's another federal grant GBI uses. If you don't comply with this, you lose them all. And then I'll get into a disclosure matter now for under the Justice for All Act that was signed, there's a $250,000 fine and up to a year in prison.
And we would be suspended from being able to use those.
So if we as a state, I'm just talking out loud, thinking out loud. If the federal government were to take a turn that Georgia didn't like, I'm not talking about what current law is, but if 10 years down the road they took a turn that Georgia wasn't comfortable with, then it would be much like the highway funds back in the early 80s. Hey, you make the speed limit 55 or else. And there's just such strong financial ties to that states are kind of brutalized into submission. It could go that way because there's significant dollar stuff to it, conceivably.
Yes, but remember two things. Number one, the industry has representatives from all across the country that have a voice in this. In other words, the feds aren't just there by themselves. So there is representation of the states involved. And if it boiled down to it, I can tell you what's going on. If the feds did something that we didn't like and we weren't going to comply with it, then what that would prohibit us from doing would be from participating at the national level. We could still participate at the state level, depending on what the changes are.
And I don't think the committee's contemplating that, so don't misinterpret me. But I mean, you look at states dealing with on the education side, the federal No Child Left Behind requirements. Another state trials consider, hey, we're going to fund education ourselves as a state. We think we can do better than No Child Left Behind, and we don't want those dollars. There's been serious talk about that. I just need to know what dollars are tied to this. What's that?
For all of their 10 kids?
Yeah, that's right.
From the very beginning, this has been a little bit different. That a lot of the development of this has actually been by the people that use it. They have a DNA advisory board that I'm also on. That a lot of these things are even conceptualized among this committee before they even get up to the FBI. So they set the ground rules, but again, the specifics are up to the states. This is just a continuation of that federal, just to give you some idea of the levels that it goes through. This is essentially outlining the same thing, but this is an annual review that every analyst has to sign. And we have to keep these on record for audit purposes. And essentially just reminding that person who can go in or what can go into the database. Convicted offender, arrestee, forensic, unidentified human remains, or relatives of missing persons. And again, Chairman, back to your point, even though that the federal law allows us to do arrestees, they're not forcing us to do arrestees. It's simply one of the things that can go in now if we so chose to. But the analyst has to sign this. Also, anything attributed to a husband or boyfriend, let's say, that you develop on a sexual assault case, it's not the perpetrator, it was the husband or the boyfriend, and we determine that's who it is, then that does not go in the system. And this reminder, again, has to be signed by these analysts every year, just as a reminder of what's supposed to go in there and what's not supposed to go in there.
I don't understand. You don't put it in if it's a domestic violence case, you don't put it in if the offender was
If he was a party to a crime, if they can prove, let's say they were separated or whatever, and the crime was committed of a sexual assault, and it happened to be the husband or the estranged husband, if that's part of the crime, then yes, ma'am, it can go in. What I'm referring to is, let's say the female had consensual sex with her husband on a Sunday, and she's raped on a Wednesday, but the perpetrator used a condom. Now, when we run the DNA, all we're going to end up finding is the husband. Okay. He's not going to go in here. Moving quickly into the Georgia statute, 62 essentially outlines that the results are securely stored and remain confidential. 63, that's only for law enforcement purposes and disseminated only for law enforcement purposes. And then 64 is anybody that violates this is a misdemeanor of a high and aggravated nature. So if somebody gave that information out to someone they shouldn't have for Georgia, it's this, and of course under federal statute it's a $250,000 fine up to a year in prison. So just as a real quick in summary for what goes in Georgia, okay, basically that forensic unknown, that blood sample from the scene, sexual assault evidence, and an incarcerated convicted offender. No profiles from victims unless they are considered a missing person. And now FBI is doing most of these anyway. So could a semen profile from a sexual assault go in there? Yes. Could subject blood at a crime scene go in there? Yes. Could victim blood on subject clothing go in there? No. No, nothing from the victim goes in there. Could the subject blood on his own clothing go in there? No. It could have been on there unrelated to any crime. He could have cut his hand on a knife. Only the sample identifier, that case number and the item number, is all that's entered in the system. There are no names, there are no numbers other than our case number. So if we get a match with Texas, all they're seeing is 06101824 number 23. They have no idea who that is. This is just showing a little growth, as you can tell, since 2000, and how many offenders that we put in since the law expanded. It's been a little bit of growth there. In CODIS hits that we mentioned earlier, forensic, we're linking 2 or more cases to each other. We may or may not know who did it, but we can tell Atlanta that, look, the same person committed this one in Macon and in Albany. So y'all need to get together and talk. The offender hits, again, we're linking someone who's either in prison or was in prison to one of these unsolved crimes. So our GBI offender hits also, since you can tell, since 2000 have shot up dramatically. The other point there, if you remember, up until 2000 it was sex offenders. You can see we only had 13 hits. Now we're up to 553 over. These are actually over that number of cases that are solved. Some of these hits may involve 2 or 3 cases, serial rapes. Just to let you know what happens when we get that hit, we pull all this data, review it, we review the DOC information, Department of Corrections. We pull that sample from our vault, we rerun it. If they are out or released, we try to speed that up. And we then issue a report to the agency and the DA that essentially this is an investigative lead or probable cause, that you've got a DNA match. We tell them who it is, their prison number, if they're still in or if they're out, and we remind them this is investigative lead and they need to do their own investigation and bring us another sample, and we'll rerun it to verify all of this is accurate. Essentially the same thing with a forensic case, except we're going to tell all the agencies involved that you've got a case, they've got a case, and y'all need to get together because the same person is doing it. And they get a report as well. One of the things that was very interesting after the law changed, we started seeing 2001, 2002, was the type of crime solved versus what was that offender incarcerated for. And you can tell what we're up to. Most of the cases solved are rapes, by far. When you look at what the offender was in for, the top 2 are burglary, robbery, and drug related. That's what they were incarcerated for. Most of the crimes being solved are rapes. So there's some other states have obtained this data that are trying to expand their law because of this.
Mr. Chairman, where this is important is that most burglars, most drug offenders get felony probation first. They don't go into the system first. We're catching them. These are being caught once they're incarcerated. Many of them have been on felony probation before they ever get to prison system. Before we get to
Would if the law was expanded, hypothetically, to allow for DNA samples on all convicted felons, do we have the resources to handle that?
Yes, with the funding, with the funding, which to hire the additional staff which is required, or to do outsourcing of the cases. That's where
Like about $9.5 million in-house.
The issue states are now facing with outsourcing, for example, Texas, 40, 50,000 samples. You're taking one type of backlog and trading it for another. You've got these swabs sitting here, so you outsource them. Somebody else, a private company, runs your data. Well, now that data's back. The rules are, before it goes into CODIS, you have to review it. So now you're sitting on a bunch of data before it can go into the system yet to review.
The result would be, though, that the number of cases solved would be far beyond 554.
Do you have any clue how many open rape cases there are in Georgia in the last 10 years? Just order of magnitude.
We'll find out.
I don't want to give you a homework assignment, but I just wondered if you did.
These men are bigger.
Do all our law enforcement agencies have the equipment they need to take DNA samples? Like local law enforcement, county sheriffs, etc.
It's essentially very simple now. With this law change in 2000, we went over to the buccal swab collection, which you're just swabbing the inside of the mouth. Everything we get from the prisons now are that, and a lot of what the agency's submitting. You can buy the kit for $1.50 from a private company. It's got 4 swabs in it in a glove, and you just go and swab their mouth and take a sample.
In the way that, for investigative purposes, the DNA sample is obtained either through the suspect voluntarily giving a sample, or the officer obtains a search warrant, or there's a court order issue. That's the way the DNA is collected.
The DLC that does all the collection, they have state contract on those kits. It's 89 cents a kit.
I have a question about collection. To go back to the very first part, the sample's taken, it's put into the folder with the name and all, goes to your lab, and you have one person that sits there and opens them up. 2 people.
2 people.
Well, okay, but they're dealing with one thing at a time. They're barcoded at that point.
Yes, ma'am. Once they're entered into the system, into our computer system, they are then assigned a case number and item number. Once that is done in that process, they hit a button, and the printer spits out the barcodes, and those are applied to the envelopes.
To the envelope, not to the swab.
The swabs are in the envelope. Sorry.
Okay. All right.
We don't have any data yet because we haven't tested them.
Well, I know.
Yeah.
Okay. I'm trying to see what possibility of switching of
Chain of custody issues from source all the way through.
But to switching them. So, okay, then they go to a... So it shouldn't happen there because the person should only be opening up one at a time.
It's interesting. No, we have discovered in the prison where people swap IDs, and they have given their DNA under somebody else's name. Well, when we get it in, if we've already got that person and we run it and compare it in CODIS, it's going to come up, and we can verify it and say we've already run this twice, and this is not the same guy. The prison goes back, does an investigation, says, oh, they were in line and they swapped IDs, trying to fool the collectors, and we end up discovering it at GBI.
Okay, but then...
Not only that, there's a furlough for that as well. If you recall, we let the agency know that there is an offender kit which gives them the probable cause to do their own investigation. So what the agency then does is going to search warrant to go get another sample that then comes in that we compare.
Okay.
So there's 3 levels.
Okay, but when you take those swabs and the person has put a number on the envelope, then they go to a technician that puts them in the thing.
Yes, ma'am.
Do they get barcoded at that point or something, or where you've got...
The tubes are labeled themselves, but the tubes aren't barcoded.
Okay. How much error, what percentage of error do you run?
0.
Technician never switches and has 2 open envelopes at a time, never
No.
switches them.
You would never have an envelope, more than one envelope open at a time. There's no need to. There's
Right.
a stack over here. You can go pull one, put it in, number 22, next swap, 23, and so on.
I think we would be discussing, all of this procedure, as I understand it, is to give you an idea as to whether there is a sample to be followed up, but it's not going to become evidence in court until in addition to testing.
Okay.
Somebody, and they call them scientists, but somebody who knows what they're doing is going to, I assume, compare more than something that's sent to the mail. This sample from this person with probably on a probable cause warrant with this taken.
Exactly. This person is going to be run at least 3 times.
Okay.
when it comes in to verify the hit, and then when the agency brings them back. And all that, of course, is a scientist looking at the data. Just for our summary here, we've got now over 123,000 total, 118,000 offenders, 4,600 casework samples. We're up to 553 offender hits, 156 cases linked, and something FBI tracks for their funding purposes are investigations aided. How many investigations did you aid with this because they link a dollar figure with an investigation? So we've now aided over 800.
Are all our prisoners in the system coded, or do you have all the samples now?
No, ma'am.
How many more to go?
7,000.
On a national level, another state's offender linked to a Georgia case, we've had 80 of those. Georgia offender linked to a crime in another state, we've had 124 of those. 28 national forensic hits and 162 investigations aided. In July, our July search, the national level, I believe we had 13 hits in 12 different states in July.
It has also had to tell many law enforcement investigators that their prime suspect is not the perpetrator because their DNA is not in the evidence.
I think that's a very important point that while we were talking about prosecution and DNA, it is this process is just as important as exoneration prosecution.
Exactly.
The laboratory stance is, even though we're part of the law enforcement agency, the GBI, the laboratory stance is that, hey, this is what the evidence says. This appears to be full. I'm sorry you don't like it. That's part of our accreditation process.
Ms. Maxwell's gone, but the example given this morning, once we ran that information and that person was released, we actually identified the real perpetrator in that case. So it goes both ways. We don't really care which way it goes as long as it's truth and accurate. That's all we want.
I've got a couple questions for you if you want to keep on going through the presentation.
Almost done. This is my last one, and we're done. It's just kind of showing how this happens. These were 2 rapes in Georgia, 98, 99. There were then 4 in Alabama, Birmingham, Homewood, Talladega, and Anniston. And then in 99, there was 1 in Chattanooga. You can kind of see here an interstate link up, I-20 and 75. And it was actually the GBI agent on the 98 case in Georgia knew some investigators in Alabama. They got to talking. They weren't online yet, sent us some data. We ran it. Turns out all these cases were by the same individual. They had similar descriptions of the individual, but we didn't know who it was. And they were eventually all linked to an offender in Georgia, to Mr. Jerry Lee Pruitt, who was actually arrested for possession of burglary tools. That's what he was serving his time for, was possession of burglary tools. So all of these cases were then solved because of that.
Thank you guys. You're doing great work. While we've got you here, we've got the experts. I know sometimes we'll come up with questions when you're gone we'll wish we had asked. Is there any other questions for these folks while they're here, the committee?
How you doing in maintaining your staff? I just read recently you're losing folk, low pay, you can't keep your folk, you train them, they run off to other agencies. Tell us.
We have a retention problem with the crime lab scientists and the special agents, and that's based around that these are highly trained professionals, and once they have received their training at a cost to the state, then they become a sought-after commodity with other agencies. And we lose many scientists to federal agencies and the private sector. We're now losing special agents to local law enforcement, which is something we've never encountered before. Working at the GBI is very difficult work. And when we have a professional man or woman that can make a larger salary and do less work, then that's very tempting off of the people.
Do you have flexibility as a director to I'm sensing you don't just say we've got to keep this guy. I want to give him a $15,000 pay raise. Do you have the flexibility to do that? Do you need what resources do you need to do that? Because as soon as I saw that in the paper, I thought about my company, which tends to be a very conservative company, face some of the same issues, and that's a matter of our own devices. You guys are funded through the General Assembly, so I want to hear what things we need to do to help solve that.
We have the flexibility to do that. It is the lack of funding which creates the problem. We prepared for the governor's staff much information on this issue, and we have pointed out that the problem with retention is not Euro-wide. It is housed in the scientist ranks and the special agent ranks. That is where retention must be given at some point if we're going to retain qualified people to do this work. And the example that was cited in the Ron Cook article in the Constitution was based around 7 DNA scientists having left every 18 months to go to the Army lab. We've lost people before. This was just the most graphic illustration. They'll make more money and they'll work less cases. Now we've replaced them. We can hire people. There's not a problem recruiting people. It's the time it takes to train them. It takes 2 years for them to go through the DNA training process. So that's cases that's unworked. And once they are trained, then they're going to solve for money. And we have scientists and agents that sign contracts with the state. And they will agree to work with us for, I think it's a 2-year period. If they leave before then they have to reimburse the state on a prorated basis. So our problem is not attracting professional men, it is keeping them, and quite frankly, the silence are going to have to roll.
It's a decision we have to make as a General Assembly, the appropriation process. Serving on the appropriation committee for several years, I used to hear your reports, and we did all we could do, but I know it's a challenge for you. I understand it.
And you and the other members of the General Assembly have been very, very helpful for the GBI in providing us with funding, as has Governor Herndon. During the time when the state budget was very tight, the GBI received resources to hire new scientists and to outsource many of our backlog cases. So at this point, the crime lab is in good shape as far as its backlog. We got it down to what we consider to be a very acceptable level of backlog cases. And that's based on the resources that are provided to us. All of that can change if we continue to lose staff because we cannot hire and train them. The backlog will continue.
I've got 2 questions that I hope will be quickies. I know through some legislation we passed this last year, we're going to expanding the tracking of folks through satellite track bracelets. I know that's being used in some contexts for paroles. Do you guys, is the GBI responsible for tracking those? Who actually executes that? Is that a contractor overseeing?
I'm unfamiliar with that program because we're not involved.
Don't touch it at all.
Still.
It's board party parole.
Is it? Okay. And hope we don't unlocate individual circuits.
Okay.
I will say the GBI is responsible for the sex offender registry. That is a part of the GCIC system.
Okay.
Maybe a presentation for another day. But the sex offender registry is next to the Georgia Lottery is the most accessed government website in Georgia, and tremendous public benefit to that.
One last question. What other entities are collecting, analyzing, and using DNA information? That's a very broad question. Outside of a law enforcement context, who's looking at DNA other than you guys?
Well, I know the Armed Services was.
They've got mine. There's no doubt about that. But
so Armed Services.
Are there businesses that?
Well, you've always got there's some research, cancer research, and some of those things that would be collected to set up and to run a test that way. But again, it wouldn't be what we do at the crime.
Yeah, and Mr. Chairman, and you bring a point about the armed services have DNA samples. I spoke to the major generals in charge of the Army laboratory system, when they have for instance, they have a rape case with a DNA evidence, they cannot submit that to that armed forces database. They have to have a suspect. They can't do a broad search. So you're as a former member of the armed services, your DNA is not being compared against unknown perpetrator. They would have to have probable cause to do that.
Okay. Mr. Director, gentlemen, I appreciate your time so much.
And as you leave, let me just thank you personally for all of your help over the years, not only with that 1983 anti-terrorism statute, you and Phil Peters, and the work that we've done with Mr. Buddy Nix, and particularly your work on the Morris Ford Bridge lynching case. I want to thank you.
Before we conclude today, I'd like to open briefly for any other interested parties. I think Ms. Garrett wanted to talk very briefly. We're still ahead of schedule by about 2 hours. I've got
Don't tell her that.
3:09, so
you got 2 hours, Maggie.
When I said quick, I meant about an hour and 15 minutes. I'm Maggie Garrett. I'm with the ACLU of Georgia. And I just wanted to just touch on a few things. Some of the things that people brought up, questions that I think I may have some very basic answers to. And also just, I guess, add a few small things. The first thing is there were a couple of questions early on about, well, if we're taking fingerprints for identification purposes, shouldn't that same justification go for taking DNA? And I think it's just important to point out what may be the obvious, but that is that fingerprints are a source of identification. DNA is a source of identification, plus a source of understanding of your entire genetic code, what diseases you might be prone to get, what your family history is, what your children might have. And so getting your DNA is a whole lot more than getting your fingerprint. And who knows what technology is going to find in the future that people can end up doing with DNA. I am happy to see that most people are saying that it's a bad idea to go get DNA from people who are arrested. We believe that there's Fourth Amendment concerns there. My position would be that it would be unconstitutional to take DNA from people who are just arrested. It's also burdensome, time-consuming, a lot of the things that people have already set out. The one concern that we have right now with the DNA testing bill as it is that you're taking samples from people, and I'm not talking about like evidence. That's something different. Evidence from a crime, I think, should be saved for long periods of time so that people can, like the Innocent Project, use those to exonerate people who end up being innocent. My one concern is that when they're taking DNA for the purposes of creating the database, they're also saving the samples. My position would be that you should take the 13 strands or whatever the 13 identifying things are, which I don't know the correct terminology for, but create that DNA profile and put it in a database, and then that sample should be destroyed. If the sample's still there, then anyone can access that for any number of reasons. And granted, there are guidelines in place, but as we all know, there are guidelines in place for lots of things that somehow get out. Somehow information that students are using for their financial aid somehow randomly appears up on the internet every once in a while, or somehow people get access to these things, and your DNA is really, really important to you. So our position would be create that profile and then destroy the samples. Because as they were saying, if there's a hit from that database, they go back, and if they're going to pull that person off the street, they're going to test their DNA again. So there's a chance for you to find out that they're innocent because you're going to test them again. Whereas if you have that DNA sitting somewhere, there's always that increased risk. So take the sample, get the profile, get rid of the sample. And then the only other things I just wanted to touch on quickly, there was a question about pat-downs and what the government can and can't do. We actually, the ACLU of Georgia had a case recently, and the ACLU of Florida had a case even more recently with this situation. Our case was protesters. They wanted to go protest. They protested for the last 12 years down at Fort Benning, peaceful protests. And a few years ago, the government said, well, you can protest, but we're going to search every single person who goes in to that protest, even though your peace advocates. And the 11th Circuit Court of Appeals said, no, you can't do that. You can't go through to a group of people who have committed no crime, or you have no evidence they're going to commit any crime, and pat them down just because of a sort of amorphous idea of threats of terrorism. And then recently, I think in the last month or so, in Florida, there was a case against the Florida Sports Center. I think it's the Tampa Bay Sports Agency that owns the stadium where the Buccaneers play. And there was a school teacher. He was patted down when he went in, and he said, "You can't pat. I'm not doing anything wrong. I'm going to watch a football game." And the court said, "That's right. You cannot pat them down. It's a government building. It's a government search. There's no individualized suspicion, and you can't search them." So the good thing is that there's case law out there saying that you can't do it. But the bad news is that as we go forward, there are more and more attempts to do this, whether it's just to exercise your free speech rights or go to a football game. And so these are some of the things I think we should keep in mind as we're going through and talking about things you can and can't do.
I have a question for DNA.
Let me address just a couple of things there, just to be sure, just to reiterate. The area of the DNA that we look at has no known relation to anything, so you're not, the piece that we're looking at can't be related to anything else about you. As far as destroying the sample right away, if we destroy the offender swabs, we lose one level of our cross check. We describe that we run the sample, we save the other swabs. If we get a hit, we pull that swab out, and again, we alluded to the fact that what do you do if you exclude one? That's one place where you might get. If you do that, you catch a squid. So you would lose a level of protection, I think, of being sure that your science is accurate. The only samples that we say that we freeze when we freeze the actual extract is when we completely consume the sample. In other words, we have a very small blood stain, very small single stain, whatever it might be, and we analyze that and pull the DNA out of that. That's when we consume the whole sample, because that's all it is. And there is never any opportunity for anybody, even the defense, to come back and say, "Hey, I want an unguided on that stuff and take a look at it." And so in those cases, we save those. Everything else, we send back to the agency. And of course, we have state statute that says that anything that has any biological use or produced profile has to be retained. That's Georgia statute. So, as far as us retaining things, we retain only what we believe we need to retain to help the system, not hurt the system, hurt individuals. And of course, again, we have state statute that says if you do have material left over, that material has to be saved. So
okay, let me get this clear.
Okay. Chairman, can I recognize Mr. Donaldson?
I think we may be so confusing. Maybe I'm confused, but there's the sample taken from the crime scene, the evidentiary sample, which I maintain would never be destroyed. Mm-hmm. The sample, and I may not know what I'm talking about here, but it seems to me that the sample taken from the person arrested in prison, and I don't know what the safeguards are, I really don't have a dog in that fight, but my thought is that, if I understand it, that profile can be recorded separately from the sample. Once the profile has been put someplace or recorded, then the sample is just, I guess, a backup to that. I don't know.
That's what it is.
Yeah. If we get a hit, we then go back, pull that swab out, and run it again.
Well, I mean, but the sample that I don't think it's a sample. The evidentiary piece from the crime scene should not be destroyed. I feel very strongly about that. As long as it may have some evidentiary value down the road, it should be maintained by whoever does it.
Right.
Chairman.
Okay. I want to get this. Okay. You take the DNA sample. You only test for one. You only run one kind of test on it, and that test can't mark anything else like illnesses or anything else.
That's correct.
Now, if you were another lab and you were using that material for medical reasons or something, could that material have other tests run on it?
It could.
Right. But what you're doing is only one test, and that test doesn't have any other markers for anything else. So if somebody goes into your lab, breaks into your computer, what they're going to get, they couldn't use it for anything else except identification.
For just one point for the committee, there's a very good article in this year's Journal of Law, Medicine, and Ethics. It's retention of offender DNA samples necessary to ensure monitor quality, and appropriate safeguards exist to protect the DNA samples from misuse.
I've got that article at the website if you'd like it.
Yeah, is it long?
Very good article.
Could we get copies of it?
I'll just give you my copies. I've got one.
Thank you.
I've got one question.
It's got some great charts that go with the two.
Representative Letterman.
I'd like a copy of your poem, too.
So far, I think I've heard a consensus by everyone who's spoken here is there wouldn't be an objection, at least up to this point. I want to ask you if ACLU has a position on the possibility if Georgia did expand its law regarding DNA samples to sample every convicted felon, not just incarcerated. What would ACLU's position be on that?
I think we always have concerns about creating databases of personal information. And I actually didn't look at the entire spectrum because I wasn't thinking that we'd be going in that direction. I was thinking more the discussion would be about arrestees. So I think we would have concerns about that. But I do think that our sort of a bigger concern, and actually thinking about the case law, as I've read through it, I know that the cases that have upheld databasing of DNA have looked at the fact that if you're a convicted felon, and I'm not sure if it says, the cases say convicted felon in prison or just convicted felon, you have a lesser expectation of privacy, and therefore that's why you can take those sources and those samples, and that's why it's different than someone who's an arrestee. So I can't remember the cases exactly on that point. I think we would have concerns about it. At this point, though, my bigger concern really is the saving of the samples, and I understand that you go back and I understand that the database has information that isn't going to give your health information. But I'm not sure that the idea of just double checking it before you pull the guy in and ask him for another sample is worth keeping those data, the actual samples in a room somewhere. So that would be my bigger concern.
Thank you.
What is ACLU position on the Real ID? I didn't hear you talk about Real ID.
We were going to get out of here.
Well, luckily,
we're going to let you go, Barry.
Luckily, I did not do all of my homework on that last night, but I probably can't emphasize enough how much we don't like it. We are strong. We work really, really hard on the federal level against that, and of course, it didn't come out our way. But in addition to it having problems of, like you said, hand over your papers, creating a huge database of everyone in this country. But really, what sort of law enforcement does that really help when you have, sometimes you have databases that are so big they're not even useful. Not to mention the fact that it's going to cost the state a ton of money that the federal government isn't going to give you.
It's another federally unfunded mandate.
Mm-hmm.
Ms. Garrett, I appreciate your time very much. We're going to wrap up today. You can stay there. You can take your seat. Going to wrap up by summarizing the draft agenda for our next meeting. And again, the reason I don't want to get, although we have considerable time left, I don't want to go there at this time. We're going to speak to ID issues next meeting. And that's going to be one of our focuses. So, Ms. Garrett, I appreciate your time. If you look at the agenda that Ms. Nerdberg passed out earlier, the second page is the draft agenda for our next meeting. Just for purposes of the record, I'll read it in, and we can discuss some of this before we leave today. Today's intent, as I said early on, was to address biological information in a law enforcement context. There are enough uses and potential issues that I thought it would take a day, and lo and behold, it has. The September 27th meeting is going to address a number of things, really the full range of things outside of law enforcement, to include public and private employment. What are public and private employers, what information should they have access to? Recognizing Georgia is a right-to-work state, should an employer make as a precondition of employment delivering and or collecting, maintaining certain information for private citizens? Public-private identification cards, Real ID is part of that. But there are also private identification cards. What should private entities, private employers be able to mandate of folks in the context of an ID? The practice of medicine, both in hospitals medical records, insurance industry. I think there was a number of references made to insurance information, and should insurability ever be tied to certain DNA markers and genetic propensities, that's something we're going to talk about, which is a key part of this next meeting in September. Physical access to business and public accessible places. What requirements and what kinds of information should folks be required to provide to get access to anywhere from a football game to a place of business to a government building to Disney World. What's appropriate, again, and where do the folks of Georgia want to fall in that spectrum? Financial security verification in the context of opening accounts, in the context of cashing checks, a number of different contexts. Retail sales environment. There's a taco place out in California whose business model is you come in once, you bring in your debit card, and we take your fingerprint. And moving forward, all we need to do is you give us our fingerprint, we'll give you a taco, we'll debit your account. Innovative business model in the minds of some, but again, we want to look at those kinds of advances and just to make sure that there's no potential abuses to that. Okay. Educational enrollment in both public and private institutions. Public and privately funded research and development. So those are the sundry topics we'll seek to address on September 27th. Should be a full-day session, so plan your schedule accordingly. But we're planning to start at 10 a.m., same place, September 27th. And look forward to seeing many of you folks here again in September. So appreciate your time, members of the committee. Any last comments, questions?
I bet those guys don't get a taco out of their robot.
The meeting's hereby concluded.